46.
Appeal is allowed.
May please, your lordship. My lord. I'm praying for, my lord, adjournment of item number 46, my lord. I have some personal difficulty. I am to leave the court. My lord, may I pay for listing the matter on next Monday, my lord, on 6th of April, my lord.
40,
My lord,
46.
46, my lord.
Right. On
6th of April may be listed, my lord.
of April, I don't think before Bihu we can have it.
My lord, matter is also urgent, my lord. I have, because of some problem, my lord, I cannot remain in the court, my lord. Some urgency is there, my lord, on 6th of April, my lord.
Miscellaneous day, we won't be able to take up so many items.
My lord.
Immediately after Bihu.
My lord. Date may be not be, my lord, on 22nd or 24th April, my lord, any other day. Not on
Yes.
22nd April and 24th April. No, not 22. I'm 22nd April to question. 22nd to the one lage. More bar council election of saving. Yes. Dibla.
May I please, your lordship? Please, your lordship. I beg to mention item number 35, your lordship. If case diary is not there, your lordship, I am on interim, your lordship.
They did not received. Again on so and so. Interim order passed earlier to continue.
Wait, please, your lordship. I beg to mention item number 30, prayer for adjournment. 30. Any date may be given after Bihu vacation. Problem.
Please, your lordship. Lordship, I beg to mention item number 21. My lord, in this case, my lord, earlier occasion in the trial court, my lord, lordship has conducted this case, my lord, as a session judge, my lord. That pleadings I have taken and annexed in the petition, my lord, annex 9 and 10, my lord. Therefore, my lord, matter may be taken. Therefore, my lord, matter may be listed before another court, my lord, because there is a decisive order by your lordships.
Okay.
My lords, I appear on behalf of respondent number 2. As per my senior's instructions and my limited instructions is that there is no such impediment.
There is an order, lordship. I have annexed. I have taken the pleadings, my lord. That is in my favor, my lord. That order also, not his favor, my lord. As per Supreme Court order, if it is conducted by as an advocate or taken by a judge, my lord, it cannot be taken up.
Item 21. You bring up the file. We'll see. 21. Yes, next.
My lord, item 19, I beg to mention here, my lord. Last occasion, direction is given to file IA criminal because to implicate the victim. So we have filed this, but it is not with records. So it may next week or your lordship may today. That IA has not.
Item 19. Item.
Item 19, my lord.
Alright. List again on. So along with the IA said to have been filed.
So if after Bihu, but notice will go then otherwise.
Alright. Given it after Bihu.
24. 24.
May I please, your lordship. Lordship, I beg to mention for item number 24, my lord, with the consent of the AD, my lord, it will come after vacation, my lord.
24.
Lordship.
Please, your lordship, my lord. Lordship, with the consent from other side, I beg to mention item number 25, lordship. The matter may be adjourned for the day, lordship. Much obliged.
It pleases your lordship, my lord. My lord, I beg to mention item number 43, my lord. Sometime may be required for taking dusty service, my lord here.
Item 43.
My lord.
Right. Chair of Learned Counsel for the petitioner list. No.
Obliged.
May it please your lordship. Lordship, I beg to mention daily list item 32, lordship. Lordship, kindly pass over the matter for the day. 32. The matter may come upon 8.
No. After view.
Here, my lord. It is there, my lord.
It is there. It.
Published.
8. Yes, all right.
Published.
What is it? Thank you.
21.
Serially material.
May I present, Lordship? Lordship, 483 application, Lordship, commercial quantity, Lordship. Alright.
CD.
Date may be given, Lordship. 23.
Commercial
23.
time.
This month. 25, 26. Published, Lordship.
Lordship, this is the 483 bail application. The accused has been behind the bar for 15 days as of today. The FR is at page 8. If I may read the FR, Lordship. Page number 8. Shall I read the FR, Lordship? With due respect, I beg to state that in connection with the above mentioned reference on 19 March 2026 at around 11:45 a.m., while I was on duty along with staff of 1/2 Section 12th APBN conducting NACA checking at National Highway number 15 within the jurisdiction of Otra Police Station at about 1:20 p.m., one truck bearing registration number so-and-so heading from Gauhati towards Biswanath direction was intercepted. On suspicion, the vehicle was stopped and searched. Upon inspection, it was found that the truck was carrying 14 cattle in a cruel and inhuman manner, tightly packed without proper space, indicating transportation in violation of law. Immediately, I informed the officer in charge of the police station over telephone and I interrogated the driver of the vehicle along with 6 other persons, namely Muhammad Umar Faruqi, 25 years, son of so-and-so, Muhammad Imran Hussain, 26 years, son of so-and-so, Muhammad Sirajul Alam, 36 years, Muhammad Mukhtar Hussain, 23 years, Muhammad Turab Ali, 60 years, and Muhammad Afash Uddin, 43 years, who is the petitioner in this instant case. On interrogation, the driver and accompanying persons failed to produce any valid documents for transportation of the cattle. Hence, there is a strong suspicion that the cattle were being transported illegally, possibly for slaughter, in violation of the applicable laws. On further interrogation, it was acknowledged that the driver of the vehicle, along with the 6 other persons, in an illegal manner had already transported the cows from neighboring states such as Arunachal Pradesh, Harmoti along the Assam border to Dhubri district via Nagaon. Now, Your Lordship, at the outset, the present accused is a daily wage laborer with no semblance of connection to the alleged offense, except for his unfortunate presence on the spot. The prosecution case, even if it's taken at its highest, it fails to disclose any specific covert act attributable to the accused person. Also, Lordship, mere presence cannot be stretched into culpability. There is a complete absence of mens rea. No material suggests that the accused had knowledge, intention, or participation in any alleged illegal act. Essential ingredient of offenses under Cattle Acts is intent and knowledge. A laborer engaged for daily wage activities cannot be presumed to know the legality of the activity. Also, it is respectfully submitted that the accused person neither owns the cattle nor the vehicle involved. His role at its best was of a casual laborer engaged for subsistence. Lastly, Lordship, suspicion, however strong, cannot take the place of proof, much less justify continued custody. Therefore, Lordship, the petitioner may be allowed to go on bail.
Your submission about suspicion, is that applicable to bail or to the trial?
Lordship, to the trial.
From Bishwanath child, my lord, it is the CDB there, my lord.
Lordship, he's
7 days in custody, my lord. Interrogation has to be there, my lord, from where these cattle were coming, my lord.
He was arrested on 19 March, 15 days, Lordship. He's a daily wage laborer, and his family is entirely dependent on his.
That's 8.
Yes.
CD 8.
Please, your lordship. That's a regular bail, my lord. Your lordship will find the FIR, my lord, page 13, my lord.
What is the case?
My lord, it's regarding, my lord, some SIM card, my lord. Some SIM cards were issued, my lord. "34 numbers of SIM cards were issued, my lord, in various names, my lord.
Is a CD.
Lordship, kindly turn to page 17 for a once, my lord. 17, the forwarding report, my lord, at serial number 5, my lord. May I read, my lord? That the accused person knowingly assisted offenders by providing SIM cards and bank accounts registered in the names of unsuspecting persons or on the basis of forged documents, thereby enabling criminals to conceal their identity while committing offences, my lord. Now, my lord, in the instant case, my lord, there are a number of people have been arrested, my lord, and all were granted, my lord, interim bail, my lord. That I have annexed, my lord, from page 19 onwards, my lord. Page 19, my lord, this Hirok Jyoti, my lord, the main accused, my lord, he has been granted interim bail, my lord. And again, page 21 also, my lord, Moinul Haq, my lord, he has also been granted interim bail, my lord. Arrested, my lord, but interim has been granted, my lord. As well as page 27 also, my lord. I have annexed 3 orders, my lord.
All were arrested on the same date.
On various days, my lord, but I am behind the bars for last 20 days, and other persons, my lord, they were behind the bar for 8 to 9 days, my lord. 8-9 days, my lord. There are only 2 petitioner before your lordship, my lord, and the allegation against us is that we have assisted, my lord. I pray for the same order, my lord. Case diary has been fixed on, my lord, 22nd of April, my lord. Page 19, my lord, is the main accused according to the FIR, my lord. Entering this.
Accused means what? Is it not the same allegation against everybody?
No, my lord, if your lordship sees the FIR, my lord, it says, my lord, first 4 lines, my lord. 61 FMS suspected mobile, 2 point of, my lord, the sales point, namely Hirok store, my lord. That Hirok store, my lord, owner has been granted bail, my lord. Page 21, my lord.
Yes, PP.
Lordship, page 16, your Lordship, I kindly see the grounds of arrest, my lord. Point number 2, 3, and 4, their involvement in the case, my lord.
Yes, my allegation is there, and I admit, my lord, but I'm
Kind of-
praying on the ground of parity, my lord. All of the accused have been granted bail, and the case diary is fixed on 22nd of April, my lord.
Were you
My lord, I am my lord. I have stated, my lord, in paragraph, my lord. I have stated, my lord, paragraph, page 5, paragraph 8, my lord, that the petitioner begs to state the petitioner number 1 is a private job holder. Well, he is working in a cloth store, my lord, and the petitioner number 2 is a, my lord, ex-panchayat member, my lord. And in the forwarding also, my lord, directly nothing, my lord, have been stated against us, my lord. This is one of some of the maybe co-accused have stated our name, my lord. I pray the same order as page 21, my lord. Sorry, my lord, page 19, my lord.
at page 19?
Page 22 yes.
Perusal of the FIR and during the period of detention of about 20 days.
20 days, exactly 20 days.
That to the fact that situated court have already been granted the privilege of interim bail. Present petitioner is also interim bail. Interim bail on furnishing a bond of rupees 20,000 with 2 sureties of like amount. Satisfaction of the learned CG. Submitted that the CD has already been called for in the connected bail application and the matter is fixed on 22nd. The matter again on
27. And it will be CGM Kamrup Metro, madam.
this order, it's Kamrup.
Yes, I think it's wrong, my lord. Otherwise, the forwarding report is to the CGM Metro, my lord. Page 16, my lord. I am obliged, madam.
Please, same order. 2 and 3 same order. Is it only 3? Oh, you say about it. 2. It's 3. This is only 3. I think already.
May I please your lordship? The bail application, the FI is on page 9, your lordship. Translated type copy. Lordship, the allegation whereof showing some obscene video to the minor, your lordship. And hence the case is registered, your lordship, under section 65 clause 2 of BNS, read with section 612 of POCSO.
All right, CD.
Yes,
And notice to respondent number 2, steps by Speed Post Street AD. List on.
But date may be fixed. What's up?
Your Lordship. Lordship, this is an application under section 483 of Lordship. The applicant is the behind the bar in more than 6 months, Your Lordship. Lordship, FIR in page number in 9, Your Lordship. This is a translation copy of the FIR. May I read, Your Lordship?
You have to see the CD anyway.
Such that case, man.
Charge it.
It
Scan copy of PCR along with CD. Again on. Also notice to respondent number.
May I please, your lordship? Lord, in this case also, the trial court record will be required, my lord. Substituted matter, my lord.
Same order.
And we on
And
27, my lord, of this month. 27. Of last month.
The matter pertains to POCSO lawsuit in this case. May I pray for the issue notice and I call for the TCR lordships.
Scan copy of TCR and notice to respondent number 2.
NDPS, my lord, regular bail, 3 months behind the bar, my lord. Only a short date, my lord, your lordship may call for serious.
All right.
Can copy, my lord.
Scan copy of TCR.
CD is charge sheeted, no. No, it is not charge sheeted, no. CD would be 22nd.
Okay, my lord. 26.
Obliged to.
May please your lordship. Lordship, in this matter, we have come to know today that this matter was earlier rejected by Justice Mridul Kumar Kolita, my lord. Hence, my lord, kindly allow us to file an additional affidavit. We'll bring that rejection order on record, my lord.
Not necessary, we'll direct it to be listed.
They have filed I've just produced this judgment, earlier judgment, your lordship. The same ground. 47 and 48.
Anyway, it has to go to the appropriate bench.
Yes, your lordship.
Submitted that the earlier bail application was rejected by another bench. Hence, list the matter before the appropriate bench within bracket.
Let your lordship. Your lordship may record my presence, your lordship.
So and so appears for
Pending counsel DRA.
Where is your lordship? So in this case, lordship, charge sheet is laid under such lordship POCSO. yet where Lordship seeking default bill, that Lordship has heard the matter yesterday, Lordship, similar to that matter, Lordship.
Similar to the same matter.
Similar but different Lordship case.
That is a different case, my lord.
That's a
Their
different
facts
case.
are different, my
The facts are different.
It's a scan copy of this.
No,
may
Lordship,
be
because
possible.
I have annexed everything, Lordship, including the petition, including the Lordship order.
He can, everything he can, but it is
Yes,
not
scan
possible
copy,
for
Lordship, is the Lordship may kindly hear for
the
a moment.
motion matter, everything.
For a moment,
and
Lordship.
everything, my
For a
lord.
moment, Lordship, I would like to take your Lordship to the Lordship
You have to
relevant
go to
date,
that,
Lordship.
Scan copy, my lord.
I may hear you, but he has to have an opportunity to reply.
Yes, lordship.
And then Lordship,
That will,
have annexed Lordship, the judgment Lordship has to see.
Why we have to
proceed.
see.
I'm relying on the same judgment, Lordship, and the trial court, Lordship court below has rejected that contention, Lordship. Therefore, Lordship, it is admitted, Lordship, that Lordship CS was put up within the Lordship time.
Facts are different, my lord.
Thanks, different, but proposition same, Lordship.
That case is fixed today.
Today, my lord. That is today. It is in the supplementary list.
Then Lordship can take up this matter along with that matter, Lordship.
All right.
Yes.
But my lord, here facts will be different because that
But-
we have to see, my lord.
Yes,
In
Lordship,
that
but
case, my lord, we have.
No,
we
he
have got-
says according to him,
Yes.
in this case also admittedly it was put up before.
Admittedly, Lordship.
If only
before-
for the limited purpose, he is paying that it was that. we have
Only,
to see, my lord.
admittedly, they
Orders
tried-
we have
Only
Yes.
question is put up and seen.
put up is saying.
endorsement, Lordship.
Yes, sir.
That matter, both the matters can be taken up, Lordship.
Because their
Yes.
orders we have seen, my lord, your lordship also seen, but here
Orders are there.
he is an ex, my lord.
Obvious.
I have to examine, we may not pass order today itself.
Yes.
Sorry to intervene, Your Lordship. My lord, in item number 9, let the TCR may be called for.
What item number 9?
My lord, it is 483 bail application, Lordship.
What order has been passed?
I,
It will be done there. Why should we call for TCR? It's not.
Thanks, Your Lordship.
May I please, Your Lordship? Lordship, commercial quantities involved, Lordship may kindly call for the TCR, Lordship.
Ready.
TCR. Yes. 27. Any date in this month? Last birth.
30
30.
to convenience of the court, man.
30. Highly authorized.
May I please, your lordship? Lordship, in this case today, as on today, my lord, it is 60th date, my lord. Statutory period is over, my lord. They were supposed to, item 57. They were supposed to obtain instruction as to whether the charge sheet have been laid or not.
Charge sheet have been laid down, my lord. Abdul Aziz,
Abdul Aziz.
my lord, charge sheet laid down, my lord. It was on 22/2026
22.
TCR?
and charge sheet number 16/26. 26.
All right. It is submitted by learned additional PP that has already been laid.
Lordship, may I kindly call for TCR, my lord.
Right, CS number so and so dated. And call for the scan copy of the TCR along with the CD and paste again on.
Obliged, lordship.
Please, Your Lordship. My lord, this is 482 application seeking transit pre-arrest bail, my lord. Take down. My lord, earlier passed some order in some cases similarly situated case, my lord. FIR is at page number 12, my lord. Some financial transactions happened, my lord. In my account beyond my knowledge, my lord. I have submitted to order, my lord. Caused by your lordship in some other cases. My lord. 14 days time may be given, my lord. I will appear before the investigation. Over it. For
This is
necessary.
why you have received notice from some other jurisdiction.
My lord, from Delhi. So PI is the judgment cover, my lord.
That will pass similar order. I
My
think we
lord.
had passed yesterday also we had passed.
Lordship, let him appear. Let him pay for
Yesterday also you made that order, no? That why? police that this will be different.
Para 5, Your Lordship.
That one you remember
Change it.
and corrected there in yesterday. You asked me if
Highly available.
in case of doubt. This
Highly available.
I'm praying for the matter to be passed over for the time. Always.
In any case, my lord, is section 6 POCSO is there, no effect to go.
let him have the satisfaction.
Lords.
Please, Lord. In this case, my lord, the petition, the annexure 2 is the first FIR. Now petition of the offending errors in the second FIR. My lord. Now annexure 2, I will take your lordship to annexure 2, page 13. So incident on 18 to 28 at 7:30 p.m. Sri Dubjyoti Kakoti. So came to my courtyard while my son Sri Vikas Mohanto was cleaning the heap of small coconuts and trash. Suddenly, without any reason, my neighbor Dibojyoti Kakoti, there is a petitioner, attacked my son so and so, so and so. So petitioner has been arrested in connection with this case. And he has also been granted bail after arrest. And some days he has been arrested. He has been released on bail.
This Dibojyoti Kakoti.
Dibojyoti Kakoti. On same day, my lord, police has again registered another case against the petitioner.
That is FIR.
One page 8. Same, my lord. Due to the I beg to their night so and so, one Dibojyoti Kakoti, son of so and so, so
Same
and so.
behavior, same case.
My lord, case is not the police has made allegation or different allegation, then he disturbed his discharging duties so and so on the day of arrest. On 18, yesterday on 10.25, he was already arrested in connection with the earlier FIR. Now your lordship will find police, while making shown arrest in this case, that is page 23. The CGMS part order, Mother. Seen the prayer of ASI Niren Das of Vidyanagar, Vijayanagar OP, when he has prayed for shown arrest of accused person, namely Dibojyoti Kakoti, while he was under in the custody, my lord, who was already been arrested and detained in jail after so and so, so and so, so and so. The officer in charge has submitted accused person, namely Dibojyoti Kakoti, so and so, he is involved in the instant case and he is already in judicial custody in connection with so and so. Hard so and so. The officer in charge has paid for showing of the accused person arrested in the instant case. The prayer of IO shall be considered on production of accused person. So then production of accused person, my lord. Then on next date, you also find page 25, 5.3 so and so. 5.3.26. The accused person, namely Dibojyoti Kakoti, has been produced through VC on strength of production warrant issued in connection with the prayer filed by IO of this case for shown arrest of the accused person in the instant case as the accused person in judicial custody in connection with that so and so. It seems that alleged offense is under section so and so, but in case diary there appears no any medical exemption report regarding of the complainant victim regarding the commission till date. On the other hand, it could be learned from examination of the IO for prayer that the medical was not done as injury was very minor. Thus, considering the matters, I found that there is no necessity of the accused person to be arrested in connection with so and so. For the purpose of proper investigation, the IO is allowed to investigate the accused person in jail premises within a so and so. Now, in the meantime, the accused has been released. Now, he is apprehending arrest, my lord, in this connection. He may be only others are available only. That's 121. 120 close 1 of 121. He may be a large one interim bail one. That also injury is minor. As per this CGM's order.
Can he be arrested in view of the CGM's order? That
I don't know, but
if he is given to be shown arrested.
Yes, this is my lord. Yes, page 25 now. regarding PS case 49.
Non 49. 49 মই bail পাই গৈছো।
All right, you never know how it is interpreted.
Doesn't matter.
And my lord,
Learned
the
counsel for
two incidents are of separate, my lord.
same day, same incident.
My lord, in my lord,
Maybe some halla, my lord, in the
there are,
police
my lord,
station.
in page 8, my lord, it is a yesterday night, my lord.
Same this there. On that day I have been
18th. Incident is of 18th
18, my lord.
inside the police station.
And my lord, one is 19, my lord, 9.
No,
That's 19.
same day. He said yesterday.
Lord, yesterday.
Had learned counsel for the petitioner and learned additional PP. This is an application under SOS. The petitioner was earlier arrested in connection with Salisbury PS case number 49
Yes, 49.
of 26 and was released on bail on
10/3/26.
10/3/26. However, on perusal of the record, it appears that the FIR of the present case, that is Salisbury PS case number 51 of 26, has been lodged by the
Page 8, my
Sub Inspector of Police. Who has lodged it? Lodged by one UBC, Sorbesor Rabha, Salisbury PS, on the basis of the same incident. And prayer was made to the learned CJM Kamrup Metro, CJM Kamrup Amingaon,
Amingaon.
for
arrest.
showing him as arrested in connection with the present case, which prayer was rejected by the learned CJM Kamrup Amingaon by order dated 5/3/26, and he was allowed to be interrogated in jail. However, since the petitioner has already been released on jail, he apprehends arrest in connection with the present case. Having regard to the above, the prayer for pre-arrest bail is allowed the petitioners. The event of his arrest shall be released on bail of rupees 20,000 with two securities for like amount to the satisfaction of the arresting authority.
Obliged.
Please, your lordships. This is a PS bail application under section 42 BNSF lordships. So, what happened in this case, lordships, as per the gist of the FIR, lordships, page number 8, lordships. The gist of the case is that, lordships, a source information was received by the police, lordships, regarding that a vehicle loaded with some stolen cattle were parked in front of the present petitioner's house, lordships, and as for the said sort of information, lordship, they have visited the place of occurrence, lordship, and found, lordship, a vehicle. And while it is searched, lordship, 57 numbers of cattle were found in the said vehicle, lordship. While, lordship, the family members of the present petitioner were asked to produce some documents, lordship, they have failed to produce, and accordingly, the vehicle has been seized by the police, lordship, and as well as the cattle, lordship. And an FIR was lost, lordship, that this petitioner, lordship, is dealing with illegal cattle smuggling business since long, lordship. And you may kindly see the FIR page number 11, lordship, last page. The name of the accused person is Khairul Islam, son of Hassan Ali, village so and so, lordship. This is the FIR, lordship. And subsequently, what happened, lordship? Two persons, lordship, claiming to be the owner of the cattle, lordship, filed a Jimma application before the learned court below, lordship. One person, lordship, Anisur Jaman, he is claiming that 41 numbers of cattle belongs to him, lordship, and one, lordship, Atabur Rahman, he is claiming that he is the 16, he is the owner of the 16 numbers of cattle, lordship. And the learned court below has passed an order. I have annexed the order at page number, lordships 15 lawsuit. May I read the order, Lordship? Page number 15, Lordship. May I read the order, Lordship? The Jimma petitioner of petition number 500/2026, 502/2020 are represented by the Learned Engaged Council as called for by order dated 26/2/2026. The report of the IO is received. The IO of this case, SI Satro Singh Patra, has stated in his aforesaid report that during investigation of this case, total 57 numbers of cattle were seized, and after inquiry at Gugamukh Weekly Market, the Maholder of the said market, namely Rupkumar Dole, has submitted a written petition wherein it has been stated that total 16 numbers of cattle has been purchased by Atabur Rahman, son of Tajul Ali, village Nadika.
Where are you reading from?
Page number 15, Lordship.
Yes.
Assam. May I start from beginning.
All right, it's okay.
A written was submitted by the Rajkumar Pegu Moholake stating that total 41 numbers of cattle was purchased by Anisur Jaman, son of Samsul Haq, village Muamari, PS Koliabor, district Nagaon, Assam. The IO has also stated in his aforesaid report that the seized cattle, or total 57 numbers, are not required for further investigation of this case. Peruse the case record and report submitted by the IO, heard both sides. The Jimma petition of the petition number 526, Anisur Jaman, claims to be the actual owner of the seized 41 numbers of cattle, and by petition number 502/26, Jimma petitioner, namely Atabur Rahman, claims to be actual owner of the 16 numbers of cattle which were seized in connection with this case. I have gone through the report of the IO and the photocopies of purchase receipt in respect of the aforesaid seized cattle annexed with the Jimma petition. Considering all of the above and going by the report submitted by the IO, I deem it fit and proper to direct the IO for handing over the seized cattle.
So it was kept in your house?
No, in front of my house, Lordship. In front of my house. Sorry, it was police has suspected that this cattle has belonged to present petitioner, Lordship, and actually it was purchased by one Anisur Rahman and Lordship, Anisur Jaman and Atabur Rahman, Lordship. And subsequently they have produced the cattle purchase receipt, Lordship, and IO has already verified the said documents, and market authority has also.
So what is there against him?
Lordship.
Heard learned counsel for the petitioner and learned it. This is an application under so and so, as per the FIR. Paragraph 2 of the bail petition. Learned counsel for the petitioner has taken the court through the order dated 5/3/26 passed by the learned SDJM S Lokhimpur in GR number 167 of 2026 pertaining to Bipuria PS case number 30/26, wherefrom it appears that as per report of the IO, 41 numbers of cattle was purchased by one Anisur Jaman, and the remaining 16 numbers of cattle were purchased by one Atabur Rahman. And after going through the report of the IO and the enclosed documents, the said cattle were given in Jimma of the aforesaid two persons by the aforesaid order. Therefore, the only allegation against the present petitioner was that the aforesaid cattle, which were legally purchased, were found in front of the house of the present petitioner. Having regard to the above with prima facie, it appears that prima facie the provisions of the Assam Cattle Preservation Act section 303 within bracket 2 BNS RW section 13 within bracket 1 of the Assam 11 within bracket 1, within bracket small a, of the Prevention of Cruelty to Animals Act, prima facie not attracted. Having regard to the above, the prayer for pre-arrest bail is allowed in the petition. 50,000. Surety.
Obliged, lordships.
My senior is on leg at another court. Matter may kindly be heard after some time.
Anticipatory bail application, my lord, FIR space 10. Small FIR, my lord. Married. Move 70. Case was registered under section 75 and 79 of BNS, my lord. I'm not named in the FIR. Two persons in connection with this case, my lord, already arrested and they were released by the learned court below. The petitioner is searching by the police, my lord, on the reason that the person who were arrested, they are my friends.
Where is the order releasing them?
Lordship, I'm not annexing, but I have the order, my lord.
Let us see.
I'm still, Lordship. I'm stating in my para 6, my lord. Huh? The release for the release order, my lord. And punishment is may be extended to 3 years. Notice has been issued to me, my lord.
This is only the bail bond acceptance order. Where is the order of the session judge?
And how they are connected, my lord, we never know, my lord.
Don't know anything.
Punishment is up to 3 years, my lord. No notice has been issued to me for asking me a pay before the investigating authority, my lord.
Why are you here then?
Lordship?
No notice issued.
No, my lord.
Then why are you here? What is
Lordship,
your involvement?
but police searching for me, my lord. Visited my house. my
Everybody
lord.
says police searching, police searching. You don't even enclose the relevant order. Furnish the order.
वो पूरा के नीडिया ना उलिया है
At least on Tuesday, you produce the order of the granting of bail. In the meantime, also call for the CD.
I'm obliged.
7. To be on 7, man. I will try.
Okay, maybe the order will reflect something.
With pleasure, Lordship. My FIR
Co-accused persons. Yes, further.
My FIR is at page 16 onward, Lordship. An allegation has been brought against me and another regarding kidnap of a girl, 17-year-old girl, and rape, Lordship. But the fact that the girl called me to go to a local mela, and after visiting the mela, when I want to put the girl into her house, she refused. Then I keep the girl in my uncle's house, Lordship. And on the same night, girl was returned to her parents. Thereafter, almost after 10 days, this FIR was lodged, Lordship, through SP Morigaon. In this respect, Lordship, I have filed another bail application for the accused number 2, Lordship. Filed AB 444-444/26, in which CD has already been called for, Lordship. This is a charges of POCSO also there, Lordship. Notice should go. I think 13. Out of the same FIR, Lordship. That bail was for Khairul. Presently, I am here for Abdul Batem.
Okay, fixed on same date.
Lordship. CD may be called for on the, I'll take steps from notice. I am praying for an interim. I am ready
CD
to
is
cooperate.
already called for, I think.
CD has already been called for in that case, Lordship.
No need to keep call separately. We'll list on the
Lordship,
same date.
maybe. I am praying for an interim protection, Lordship. I am ready to cooperate with Lordship.
Allegation is specifically against you.
Lordship.
But Mr. Learned Counsel for the petitioner and learned is submitted that the CD in connected bail application AB 444/26 has been fixed on 22/4/26. Hence, list the matter along with AB 444/2026 on 2nd April 26.
Should I issue notice in this case separated to victim, Lordship?
I think that will do. Earlier case, same victim.
If court direct, I may take Lordship step, no problem.
All right, we should notice to respondent number 2 also.
Lordship.
List the matter along with Lordship.
Yes.
May it please your lordship. Lordship, this is a pre-arrest bail application. My lord, in this case, what happened? One accident took place in 2018, and the vehicle was intercepted, and the driver of the vehicle, one Habinur Islam, produced the insurance policy before the police, and it was found subsequently fake insurance policy, my lord. The petitioner before my lord he's not he is the agent who has issued one insurance policy, but he has not issued this policy as mentioned in the FIR. My lord, kindly, I have issued the policy, my lord. I have also annexed page 23, my lord.
So what is the case against you?
Against you, my lord, I am also involved. But I am not involved, my lord. I have issued the policy number. This is different, my lord. But FIR, the policy number, two numbers are different. My lord, the page 17, my lord. Page 17, my lord, can come to page 17.
Your name is Nur
My name
Alam.
is Nur Alam. My lord, the para 1, my lord, page 17, the United India Insurance Committee Limited, Company Limited policy number 13050531118P444 in the name of Akasal. He is the owner of the vehicle. My lord, submitted, which was valid till 15/11/2019, submitted to the Tura police by driver of the vehicle so and so is found is fake and manipulated document. Now, my lord, my policy, my lord, I have annexed. Page 23 is the original, page 24 is the type copy, my lord. My policy number, which I have issued, that is 13080. But the FIR shows that 1305053. So, but perhaps, my lord, they manipulated, my lord. I have no knowledge about that, my lord. I have, which I have annexed, issued, I have annexed, my lord. Page 23, my lord. So, my lord,
now annex may be the genuine, my lord, but when produced before
no, it cannot be, my lord. It is online process, my lord. It cannot be, my lord.
at this stage, my lord, that may be called for. And
My lord, my submission, my lord, I have to cooperate, my lord. This is very much necessary, my lord. I am also ready because since I have not issued, I have issued this policy, my lord, it is very much necessary, my lord, my cooperation. Otherwise, my lord, I may be in trouble. My lord, if my lord, yes, insurance, I am the agent, my lord. I have the owner and driver, my lord, they have perhaps they have done something, my lord. I will submit my original policy, my lord, which I have issued, my lord.
To the same person.
Same person, but one thing, my lord, the policy which I have issued, it was expiry date was 27, my lord, page 23.
Yes.
My insurance policy expiry date and time, my lord, 27/11/2019. But the FIR, my lord, page 17, it shows that, my lord, it was valid to 27, it was valid up to till, my lord, paragraph 1, page 17, valid till 15/11/19. It is also, my lord, my policy is not, is different, my lord. Page 23 shows, which I have annexed, it was valid up to 27/11. But they have produced by the driver of the vehicle, it shows that it was valid 15/11/19. This is also different, my lord. My submission, my lord, I am also ready, my lord, to cooperate, my lord. Submitted. It is a documentary evidence, my lord. If my lord, allowed me, my lord, nothing will harm, my lord. It will, because all the documentary evidence, my lord.
Is the date of issue of this page 23?
Issue, my lord, I have issue 28/11/18. 28/11/18. Only two numbers are different and date of validity, my lord, is different.
Date of validity is also nearby.
Nearby.
This is 27, that is 15.
15.
It is even earlier.
But my lord, I don't have knowledge. I have not issued this.
No, what I am trying to find out, if he had this one,
My lord.
why is he using that fake one, which is expires even earlier?
Maybe in some case.
Incident, my lord,
First party, maybe.
incident took place 17/11/18.
This is what, third party or comprehensive?
Another, my lord, the two numbers, policy numbers. Two numbers are different, my lord. Oh, I have issued, my lord, policy number 13080, but their FIR shows that 13050. 8 is my 8 is shown 5, my lord.
What is the vehicle?
Vehicle, my lord, a vehicle pickup, my lord. Number registration number was also same. The policy number is different, my lord.
No,
That is
not pickup. Page 23 is a motorcycle, my lord. Bajaj Auto Limited Discover. Its type of body solo and pillion. It's a motorcycle, my lord.
But my lord, the incident took place. That is, my lord.
It means this has nothing to do with the vehicle, that vehicle. This is in respect to a motorcycle.
Motorcycle, but
Accident took place in respect of a pickup.
Pickup, but my lord, one thing, my lord, while I have.
So how can you say that you issued a genuine certificate against the vehicle which was involved in the accident?
My lord, one thing is, my lord, while issuing the certificate, I have done only one mistake. That is, my lord, in place of pickup, I have written two-wheeler. That is my fault only. That is, my lord. It is, I have also stated in the paragraph. My lord. Otherwise, my lord, the policy number is something different, my lord. But I am ready, my lord, to cooperate. Otherwise, my lord, it is a documentary evidence, my lord. If something is found, my lord will make it, my lord. Yes. Just I am paying one chance to produce the document, my lord. Cooperate the investigation, my lord. If something is found, my lord, I have no objection, my lord. My lord will take it then. Only playing, my lord, since I have not issued this order as per record, my lord, which I have submitted before my lord. But page 9, paragraph 7, I have stated, my lord.
The registration number is same.
Registration is same, but policy number is one number, my lord, 8, which I have issued 8. They have submitted which was 5, my lord. My case is that my number is 13080, but FIR shows that they have produced the policy number 13050.
Perhaps, my lord, if this is genuine and they have produced one document, my lord, changing that as being a pickup vehicle and also the number slightly changed. Maybe, my lord, maybe the owner and driver maybe. Don't know.
I produce, my lord. I will cooperate. Cooperation will clear, my lord. It will be clear from my lord investigation. My submission, my lord, it is very necessary to submit my document before the. Nothing will be changed.
Heard learned counsel for the petitioner. Additional an application under so and so. As per the allegations contained in the FIR, an accident had taken place on 17/11/2018 involving one Mahindra pickup vehicle. But in course of investigation, it was found that the insurance policy aspect of the said vehicle is a fake one, that the present petitioner, who is an agent of United India Insurance Company, is involved in the issuance of the said fake insurance policy. Where it is submitted on behalf of the petitioner that being the agent of the insurance company, he has a genuine insurance policy, but mistake which has been annexed the present bail application, but mistakenly the vehicle has been shown as a two-wheeler in the said policy. All for the CD. It is provided that in the event of his arrest, the petitioner will be released on interim bail of rupees 50,000 with one surety. I would like amount to the satisfaction of the arresting in connection with the aforesaid case. Further provided that the petitioner shall cooperate with the investigation. Is the matter again on
29th April.
Can my lord within 10 days?
You have said when I will call, you will appear.
I am deeply.
Election time may not be time
May
for
not.
to appear.
I am deeply.
May I please, your lordships?
Yes.
In this case, my lord, one, my lord, a motor vehicular accident took place in the year of, my lord, 2021, my lord. Wherein, my lord, the petitioner was the driver, my lord. And at that moment, my lord, matter has been amicably settled, my lord, in between the parties, my lord. And but as the, my lord, already, my lord, FIR has been lost, my lord, and registered, the, my lord, concerned police station has declined to accept that, my lord, compromise, my lord. Thereafter, my lord, this petition has been filed, my lord. Already, my lord, matter has been compromised, and this honorable court has issued notice to the, my lord, respondent number 2, that is, my lord, informant. Already, my lord, today appeared, and they have also, my lord, I have received the copy, my lord, one affidavit, my lord, stating that they have no any objection, my lord. And in this regard, my lord, and similarly situated matters, in so many matters, my lord, this honorable court has passed several orders, my lord. I'm placing.
Those are related to matrimonial issues. This is a case of death.
But my lord, this type of cases also, my lord, I have submitted the, my lord, orders, my lord. So many orders are there, my lord. So kindly, the matter, my lord, already settled, my lord.
What is
And
the section now? 304A.
Yes, my lord. And my lord, the petitioner, my lord, is since, my lord, the day of accident, my lord, he is also suffering, my lord. Has been on the some, my lord, sympathetic ground, my lord, this petitioner also sustained, my lord, grievous injuries, and since then, my lord, and on, my lord, sympathy, my lord, they have, my lord, settled the matter, my lord, in between the parties, at the presence of some elderly persons, my lord.
This case, charge sheet has been laid.
Yes, my lord. The appearance, my lord.
Is there any eyewitness?
No, no, my lord. Night hours, my lord. My lord, 7:30 p.m., my lord, on highway, my lord, abandoned place. There was no any eyewitness, my lord.
Yes, PP.
Otherwise, Marat, we have to look into the TCR, but now national number 2 has appeared. Yes. Right. Regarding any witness, Malat, being a short date, Malat, after bifurcation, TCR may be called for, Malat.
The charge sheet was before us. We could have seen if there
Well-
are witnesses or not. So let us call for it.
TCR.
Because they are not witnesses to the case. So you cannot say that chance of conviction is remote or bleak because there may be witnesses who have seen the
My
incident.
lord, your
They
lordship
may
is
prove it.
absolutely correct, my lord. But my lord, matter, my lord, already, my lord, settled in between the
What is
parties and
difference
so
between
many.
this kind of matters and matrimonial kind of matters.
This type of also, my lord, so many, my lord.
All right, we'll see the CD once.
My lord.
Learned counsel for the petitioner and learned additional PP, learned appears for respondent. Respondent number 2. In order to dispose of the matter, it would be necessary to peruse the and copy of the TCR. Accordingly, call for the same. Place the matter again on.
Obliged, my lord. Much obliged.
Earlier, my lord, I had mentioned this. Mentioned 2 point, my lord. That is lordship find that and accept 10, my lord. That is up to you, lordship. If lordship consider it, that is up to you, lordship.
Annexure?
And accept 10 at page 63. That is lordship order as a session judge. One revision petition was considered by your lordship.
Now, what is the issue here?
Here I am challenging the criminal complaint petition, my lord. And the order dated order taking the cognizance, my lord.
So this very order.
This is not very order, my lord. This is the one part of that, my lord. In the complaint petition, they have challenged the
In
cognizance.
this order, cognizance has been taken.
This order was cognizance has been taken. 21. 21/12/2024.
No, you are referring to order dated 24/3/25. Page 63.
Yes, that is lordship's order.
Yes.
What happened, my
By
lord?
this order, I think cognizance was taken.
No, lordship. No, but lordship has not taken the cognizance. Cognizance has been taken by JMFC, my lord. And in the by agreed by that order, my lord, they have the pay.
No, see the bottom line.
Yes.
I have found prima facie materials against the accused so and so, hence cognizance is taken of the offences. So you are against taking of cognizance.
He, my lord. He is the complainant.
Better go to some other bench.
Yes, my lord.
That also was lordship basically, lordship did not pass anything on merit. And 21/12/24 was passed by the lower court. So
The fact that cognizance has been taken shows application of mind. So he is challenging the cognizance.
no lordship, not your,
Not mine, but I have agreed.
Yes.
Second cognizance after committal, isn't it?
No, lordship has just passed an order saying that it may be because the page 66 is the order where lordship has said nothing was discussed on merit, clearly saying.
So this is the quoting of the order of
order.
Yes.
Page 66, if lordship, if I may read para number 5. It is, lordship, may I read? It is seen that the next date fixed for hearing of the complaints petition is fixed on 5/4/25, which is just 10 days away from today. And therefore, instead of deciding the instant revision petition on merit/maintainability, I deem it fit to dispose the same with a direction to the learned JMFC to hear and dispose of the petition on number such and such of the complainant as expeditiously as possible and without any further delay. So there is a specific line saying that there is nothing has been decided on merit. It's up to lordship. I am not I'm trying pointing out what is there on record.
No bar actually.
No bar. That's what it's actually. There is no bar because there is a specific line saying that I have not commented on.
No, actually, my lord, what happened, my lord, if it is convenient to your lordship, my lord, I am ready to submit, my lord. But as per the Supreme Court, if any advocate conducted a case after the taking the chair, my lord, it is barred.
Advocate.
And the judge, my lord, and also judge, my lord, also judge, my lord, also the honorable judges. It is up to your lordship. It is convenient to your lordship, my lord. We have no any objection. Just this is my duty, my lord. I have to point it out, my lord. Satisfaction is up to your lordship, my lord.
The rule of recusal, lordship, in my respectful submission, what happens that there is a personal, and if there is a particular order where lordship has already expressed an opinion,
ultimately what happened,
expressed an opinion, then say again sitting on that opinion, that would be here when there is a specific line saying that nothing has been said on the merits as well as on maintainability. In my respective opinion, there is no bar, but lordship, it's up to lordship's lordship's decision whether this matter will be taken up.
It will be safer to send it. List the matter before another bench without me. On give a date.
After date, any date may be given.
And at 29, I have some other cases. A made due. First to the line. Full make assessment, please. 6.
Let it be on 8 May, if it is not inconvenient for my.
8. Well, the may be continued, my lord.
Interim order passed earlier to continue the next date of listing.
Deeply obliged.
May I please, your lordship? This petition is under section 528 PNS seeking quashing of the FIR as well as the subsequent charge sheet filed in the case, my lord. The FIR is at page 18. If I may please, page 18, my lord.
We can't go for final hearing. No time for that now.
The interim with the trial court proceeding may be stopped, my lord, please. It's entirely civil in nature, my lord.
Third learned counsel for the petitioner. Learned counsel for respondent number 2 is also along with learned additional PP. File Wakalatnama for respondent number 2.
Yes, ma'am. We have filed for that.
Wakalatnama has already been submitted on behalf of respondent number 2. Is the matter again on after question?
In the interim, if a lordship may stay,
Interim order, if any, to continue till the next date of listing.
Please, your lordship. This revision petition has come up for the first time. The petitioner before your lordship, he had faced a trial for the offense under 326 of the IPC, my lord. Trial court convicted him under section 326 and sentenced him to undergo 2 years imprisonment. An appeal was preferred, my lord, and the appeal was dismissed. So against the concurrent findings, we have come before this honorable court. The issue here, my lord, among other issues is, in a 326 case, my lord, it's grievous hurt caused by a sharp weapon. The medical report or the medical opinion has to be brought on record. This is a case where, my lord, the MO was not examined. The medical report was not exhibited. The trial court did was when the victim came to depose evidence, the victim came with a severed arm. Her arm was amputated because she had undergone surgery. The trial court took that into account that her arm was amputated. So it must have been caused because of the injury which was inflicted by the accused. And what the trial court further did was held that since the defense had not disputed the genuineness of the medical legal report, so the medical legal report is read into evidence under section 294, subsection 3. Now, your lordship knows that that can only be done when the documents are first brought to the notice of the accused under 294(1) and the accused is called upon for admission and denial of documents. If the accused does not dispute or admits, then that can be read into evidence. Now, that was not done. Directly, the trial court came to a finding that since we have not disputed, now we could not dispute because the document was never exhibited. That because we have not disputed, so it is read into evidence, and it formed an opinion that the amputation of the arm was because of the injuries which was caused by the accused. Appellate court also does the same thing. Appellate court says that though the medical report is not there, medical evidence is not there, oral evidence suggests that the victim had sustained an injury and she was under treatment for 28 days. So the offense under 326 is proved. If your lordship will kindly see specific finding to that effect, my lord, at page 25 of the petition, my lord. There's a finding of the trial court, my lord. Paragraph 20, my lord. Page 25, my lord. Page 25, my lord. Bottom part, my lord, paragraph 20. Point was also raised in appeal, my lord, and update if your lordship will come to kindly page 45.
Where is the appellate finding?
Page 45. Page 45, first paragraph, 32.
You may bicker about 294, but the fact remains that her account of the injured witness could not be shaken in cross-examination, and severed hand is there for all to see.
One aspect of the matter that her arm got severed, madam. Now her arm was amputated because she gave evidence that she went to the hospital. Her arm was amputated because she was in the hospital for 28 days. Now the underlying cause of the amputation, whether it might have, my lord, quite possible that it was because of the injury inflicted by me, or it could have been because of an infection.
Yeah, that depends on what she has deposed.
No, my lord, but then for unless and until
As to how she got the injury.
the injury part, my lord, she has stated. There is no other eyewitness. She stated that I have inflicted the injury. Now, for the offense to come under 326, if the amputation of the arm is to be taken to have occurred on account of the blow inflicted by me, so unless and until the doctor is examined, the finding as to why the arm got amputated, my lord, whether it was because of the injury which was caused by me, or whether it was for any other, the court could not have speculated, my lord, that part. My only contention before this honorable court is that just as we cannot speculate at this stage that it could not have been because of any other reason other than my inflicting the injury, the learned trial court as well as the appellate court also could not have speculated that this was because of the injury caused by me, my lord, unless the doctor was examined. This finding, when the medical evidence is taken on record, saying that I have not disputed it without giving me that opportunity of disputing it, my lord, that angle of prejudice remains, my lord. In my respectful assumption, this is, my lord, at best a case which has to go for remand back for the doctor to be examined, for me to be given that opportunity of cross-examining the doctor on the cause of the amputation of the victim, my lord. That finding is prima facie incorrect, my trial court's finding.
Otherwise, my lord, if doctor's evidence is not there, but the root cause, my lord, is because of the injury, my lord. Maybe during the treatment, his hand is amputated, my lord. But
No, If the hand had got severed as a result of the procedure carried out at the hospital, that is a different matter. But here the evidence is that during the act itself, her hand got severed.
The vital witness, she is the victim, is the badly injured.
If the hand got severed during the incident itself,
My lord, will
then the question of medical evidence is.
My lord will kindly come to page 17, her evidence, what she has stated, my lord. Page 17, my lord.
We are on page 37. I think this is the appellate discussion.
So here also it says that if she has suffered an injury in her, cut injury.
You are reading page?
No, it same. Has also written the same thing.
Yes.
Page 37 will suffice, my lord.
Yes, she was sweeping the courtyard when her 3-year-old so-and-so, that her even cry removed him, threw her on the ditch and started to hew her with dowel, that her right hand was severed, and the accused hewed her on the head and her left shoulder, and severed her nerves, torn and also cut in her head. So that hand was severed, that she says.
The next page you'll also will see she was taken. There were stitches there. Then she underwent treatment, my lord, and in her trial court evidence also she has deposed to that same effect. Now, my only contention for this.
No, that is cut on her left hand shoulder, nerves were severed and stitches had to be given there.
Yes. That is one aspect of the matter. Now, the doctor who has examined her, my lord, the doctor who has given the stitches, the doctor who has done the amputation, my lord. In a if it had been a case of 323, my lord, medical opinion would have been perhaps not that crucial, my lord. But for a 326, when it's a specific case of the prosecution that her arms were subsequently amputated, my lord. So what was the root cause of the amputation? This is what she has stated, my lord. Unless and until the doctor comes and at least corroborates this aspect that, okay, this has.
No, not subsequently amputated. She says it's amputated there itself. Got severed.
Severed, and it was only skin.
In her evidence, my lord, will kindly see. Page 18, my lord. First paragraph, my lord. First paragraph, last line. She deposed further that her right hand is amputated from below the elbow joint. The amputation would have only been done by the doctor, my lord.
This is right hand is amputated from below the elbow joint. It does not necessarily mean it is in a hospital.
Because but she has stated that she was in the trial court has also she has stated that she was admitted for 28 days for treatment, my lord.
Yes,
so this
suffered different injuries. That is for the purpose of saving the life.
Unless and until that aspect comes on record, my lord, by examination, because the doctor was there, my lord. There was no reason for the trial court to not examine the doctor and give a finding that we have not disputed the medical report. That dispute was there unless and until the document is put to us, my lord. When a procedure is prescribed, my lord, that procedure has to be complied with in the terms in which it is done, my lord. 294.3 cannot directly come without 294.1, my lord.
No, we are not there yet. We are on the question of, well, if from the evidence of the victim herself, it transpires that the hand was severed. Then
our contention before this honorable court is whether this is sufficient to prove that the amputation or the severing was caused only because of me, because of my act, my lord.
And that is what her testimony says.
It is her testimony. There is no other witness to that effect, my lord.
You know the law on that.
My lord, but my lord, the fact is that in a 323, it could have been very well understood, my lord. The victim comes and deposes. When the victim is specifically making a point that there is an injury which was inflicted on me, I was taken to the hospital, my hand was amputated, I was there in the hospital for 28 days, my lord. What was the root cause for the amputation? Whether it was because of that hacking done by me or whether it was because of some underlying, that evidence has to come out, my lord. If that evidence comes out and it is found that it was because of my act, I get convicted. There is no other way out.
No, what more could she have said? She deposed how you came, threw her into a ditch, used a dowel, started hewing her, severed her hand, hit her brain. What more could she say?
But her evidence part is correct, my lord. Her evidence part would suffice otherwise, my lord. But unless and until the medical evidence is brought on record, I get prejudiced because I am not able to confront the doctor or confront the prosecution as to the exact cause which led to the amputation of the hand, my lord. That is something which has to be examined, my lord, in my respectful submission, my lord. Because trial court has not given its finding based on the fact that the evidence of the victim suffices. The trial court gives a finding that this medical legal report proves that this has happened, my lord. And appellate court also gives the same finding.
Had it been the requirement of law that it must be corroborated by the medical report, then we could have said that the court acted with material irregularity. No, where is the material irregularity?
My lord, here that may not be the mandate of law that every injury has to be proved by the doctor, my lord. But when the trial court gives a finding, relying as well trial court as well as the appellate court gives a finding relying on that medical evidence which has not been brought on record, my lord. So
Where is the
perversity
reliance by the appellate court?
my lord.
Where is the reliance by the appellate court?
In para 32, my lord. The appellate court says that the oral testimony is sufficient, my lord. Victim
Yes. So he has not relied on the medical report.
My point, my lord, because my specific contention before the appellate court was that this medical opinion was not taken into account. My lord, medical evidence was not there. Doctor was not examined. Doctor had to be examined in this case, my lord. Unless and until my lord, I get the opportunity of the medical evidence is brought on record, and I get the opportunity of confronting the doctor on this point, my lord. The prejudice, the element of prejudice remains, my lord. That part of the trial court's finding has not been negated by the appellate court, my lord. My respectful assumption that is your lordship will.
Appellate court has come to its own finding. The necessity of negating specifically. Appellate court has said that this is enough.
No, but we have specifically raised this point, my lord. When we raise a ground, my lord, it is that ground has to be considered because trial court gives a finding, relies on the medical report, and in fact, the appellate court says that it is only relying on the oral evidence of the witnesses, my lord. Whether the offense falls in the category of, because if we examine this issue on principle, my lord, whether an offense falls in the category of 320 or 319, only by oral evidence that may not always be possible, my lord. At this stage, if your lordship at least issues notice and calls for the records, my lord, this issue may be examined, my lord. This person is already in custody he's been sentenced to 2 years and is already in custody, my lord.
All right. Heard Mr. Learned Counsel for the appellant, granted additional PP. Any private respondent? No.
Yes, informant, my lord.
Notice to the respondent number 2 by speed post with AD within. Is call for the PCR. Is the matter again on?
I is there for bail, my lord. He's in custody.
You can forget about that now.
But only 2 years imprisonment, my lord.
Otherwise, in 2 years, 3 years, we don't object. But this type of cases, my lord.
Only 2 years imprisonment, my lord. That can be considered, my lord. Had it been more than
It
2
has
years,
to be
3 years, my lord.
Mr. Nawaz, count yourself lucky that I haven't kept it for chamber today.
My lord. No, I also didn't notice. Maybe reflect on that a bit.
Issue notice on the eye.
I'm deeply obliged, my lord.
Wait, please, your lordship. This matter, your lordship, the FIR is at page 70. Basically, your lordship, here, the one accused person was arrested in a mobike, and your lordship, 100 bottles of codeine was recovered from him. Now, your lordship, on the basis of the statement of the co-accused, this particular petitioner has been, your lordship, arrested. And in fact, nothing was recovered from the petitioner. And your lordship, I have taken 3 grounds in this case for bail, your lordship. The first one is, your lordship, with regard to that fact is that
He was only arrested on the basis of the statement of the co-accused, number one. Tufan Singh is their lordship. Second part, your lordship, is with regard to section 36B of the BNSS, wherein your lordship, it is mandatory to your lordship have a signature of a witness in the arrest memo. That is not there, your lordship, and in fact, I'll bring that on record. And then third is with regard to the fact that section 47 and 48, your lordship, that was not clearly complied with, because your lordship, what has happened, they have given that. But in this case, what has happened, he was arrested on the basis of the information given by the co-accused. But in the arrest, in the 47 and 48 note, it stated that the same thing was given to both of the accused persons. The same thing has been given. Here is stated, that was not stated, it is that it was recovered from him. That's the only thing. But in the FIR, in the forwarding report, there is nothing to show that it was recovered from him. The person was arrested, that person was arrested in a mobile, the other accused, and then it was recovered from him. He stated that this was, I have taken the bottles from so-and-so, and then this petitioner was arrested. This is, now your lordship will kindly, before going into any other thing, I'll just point out the first, your lordship, mandatory provision which was not done. If that is enough for your lordship, then I will not go to the other further. Hey, Eddie. The arrest memo 36B compliance part, your lordship.
Is the page?
So I'm just pointing it, this is a certified copy. So kindly see that. This is the arrest memo, your lordship, serial number 9. Name, address, and signature of accused to arrest. Then your lordship, name and address of witness. In the name and address of witness, your lordship will see signature with date and time is Biddut Bikas Kolita. Biddut Bikas Kolita is the accused. Then again, signature of the arrested person is Biddut Bikas Kolita. So in this case, your lordship, there are no name and address of the witnesses, no sign signature of the witness, your lordship. That is where the mandatory part has been, your lordship, violated. In that regard, your lordship, I'll just forward the judgment of this coordinate bench of this honorable court for your lordship reference. Otherwise, there is a judgment of the honorable Supreme Court. These two judgments, recent judgments of the honorable single bench, I'm referring to. One is that point, only on that point, whether that is mandatory, have to be provided, and can be bail granted under that condition, your lordship. First is Abu Shama, that is, and the second is Amirul Islam. So Abu Shama, your lordship, will kindly take up paragraph 7. Here, lordship, kindly take up paragraph 7 in Abu Shama. And 8. Here, your lordship, that part is mandatory. 36 is mandatory, and on that basis, bail can be granted. And on the basis of the judgment, it has referred in para 9 of Abu Shama that the ratio laid down in the apex court in the case of Basu, your lordship, the VK Basu, the honorable court says that it is violative of Article 21 and 22(1) of the Constitution, and therefore bail can be granted. And in the second case, that is Amirul Islam, your lordship, the same fact has been taken, the same ground has been taken at paragraph 25. Right. 25, 26, and 27. There also, your lordship, a second case, that is Aminul Islam. These are all judgment of coordinate bench, but Basu is of Supreme Court, your lordship. Both the judgments have referred Basu's case. Para 25, 26, and 27. So this being a mandatory part and violative of Article 21 and 22(1) of the Constitution, your lordship, the petitioner is entitled to bail. Secondly, your lordship, he was arrested only on the statement of the co-accused. The third point that I am pointing out is with regard to the section 47 and 48. Here, it has been stated that the codeine has been recovered from the possession of the arrested person. That is not true. It is incorrect, Your Lordship, grounds of arrest. Should have been that his name has been referred to by the co-accused, therefore he has been arrested. 29 is there, section on the NDPS. So therefore, Your Lordship, basically this petitioner is entitled to bail only on these two grounds itself. Your Lordship. And in fact, I'm not going to all.
Hello,
You've stated the wrong ground.
No, regarding my lord, 36 notice, my lord, we'll go by the record, my lord, whatever the record says, my lord. And I have also perused the scanned copy of the record, my lord, and I have not found them on the signature of the witnesses, my lord. That I'll go by the record, my lord. And regarding, my lord, the 47 and 48 notice, my lord, there is no violation, my lord. Because my
No,
lord,
in 48 notice, you said it is recovered from his possession, but it was not recovered from his possession.
48 notice, my lord, it is given to the, my lord, one Ritamani Kolita, my lord.
But the ground
What is
number
the ground
4.
of arrest, my lord? The accused persons were committed above mentioned offence for which they have been arrested and produced before the honorable court. This is the intimation to the, my lord, family members of the accused person, my lord.
That is not, that by itself would not have been sufficient anyway, because what is the offense?
No,
That has not been stated.
During investigation, it is
What
found
is
that
the offense that has been stated only in paragraph 4? D, sorry. Yes.
Yes, during investigation, a huge quantity of triple and hydrochloride and codeine syrup recovered from the possession of the arrested accused person. What is the wrong, my lord?
It was not from his
Because
possession.
after the arrest, my lord, this notice was served to the family members, my lord. That means during investigation, a huge quantity of so and so phosphate syrup recovered from the possession of arrested accused person.
That is not from this Vidyut. It was recovered from the other.
Conspiracy, my lord. In case of commercial quantity, my lord,
That is okay, then you should have said that.
the recovery is not signed qua non, my lord, in case of commercial quantity.
Anyway, since you have already considered on 36, then
Go by the record, my lord. I am not considered. I'll go by the record, my lord.
going by the record, you have considered.
Yes, my lord. That word, my lord, lordship, mention or not, that is up to this honorable court, my lord.
Okay.
And
you have
regarding my lord,
difficulty.
Koeku's statement, my lord, during investigation, my lord, the arrested accused person's statement has to be recorded, my lord. Otherwise, my lord, how can the police will go further, my lord?
Yes, it has to be recorded.
There has to be recorded, my lord, because my lord, he is the person who has supplied the contraband, my lord.
We agree. It has to be recorded.
Then, my lord, whatever my learned friend has submitted, my lord, on the basis of Koeku's statement, my
what
lord,
to do?
how the investigation will proceed, my lord? If the Koeku's statement is not relied on, my lord, that means investigation will have to be stopped after arresting the main first accused person, my lord.
State of Assam should file a review petition before the Supreme Court, wherein it has been held that is applicable even in bail, that cannot be arrested on the basis of statement of co-accused.
Co-accused statement, my lord, on the basis of co-accused statement, person cannot be, my
Why
lord.
are you telling us all this? Tell him
One thing
up
is
there.
clear, my lord.
Yes.
One thing is clear, my lord.
What?
As far on the basis of co-accused statement, a person cannot be convicted, my lord. But during investigation, there is no such bar, my lord.
There is such bar. That subsequent judgment has clarified that even for the purpose of bail, that is to
Even
be
for the purpose of
applicable.
bail, my lord, but for the purpose of investigation, my lord, a person can be arrested, my lord.
Yes, he can be arrested,
Supreme Court
but
has
we
never
are on
said
bail
that on the
now.
basis of co-accused statement, no person can be arrested, my lord.
We are now considering bail. Yes, next.
Lordship has passed the order.
Us in chamber.
Much obliged.
Please, Your Lordship. Prosecutor side was supposed to file an objection today, Lordship.
Who will file objection?
Arcade Surgery will appear, for NCB, he is in vote number 1, just phone me, will be taken after some time,
It is searches submitted, my lord.
My lord, he's in jail for about 52 days, Your Lordship. This is article, my lord.
Call for the TCR then.
My lord, only 6 grams were recovered, just above a small quantity, Your Lordship. Perhaps there the container May,
If it is intermediate quantity, you can go and appear there.
I'm the
What will
local,
consider?
I'm the local person of that locality, my lord. I will
That
face
is
the
what?
trial, your lordship.
If you want order from us, we have to examine the TCR. If
My
you
lord.
want to appear there, go up to you.
This year may be called.
All right. The charge sheet has already been submitted by.
What date may be given?
Yes. Call for the scan copy of TCR with CD.
Bless you, lordship.
May it please also. This is a regular bail application matter. Petitioner is behind bars for 119 days, my lord. FIR, my lord, is at case number 16. The main allegation is that, my lord, the victim had allegedly committed suicide. And the FIR has been registered, my lord, under Section 69, 1172, 296, 351, 2, 351, 3, 108 BNS. May I read the FIR, my lord, at page number 16? With due respect, I beg to state that my daughter, Asimun Khatun, aged 23 years, had a romantic relationship for the last 3 years with the aforementioned accused, and the said accused, by promising to marry her, had developed physical relationship and also introduced her with his family. On 11/7/2025 at around 7 a.m. in the morning, the said accused took my daughter with him by saying that he will take her to his house. After keeping her for the entire day, the accused said that he was not going to marry her and assaulted her, and later on brought her to Vella Road in Borpeta district.
Earlier, AB was rejected.
AB was withdrawn, my lord.
What is the name of
no, it's
the
rejected, my lord. Actually, rejected.
Mofidul?
Mofidul.
Thereafter, he was arrested.
He surrendered, my lord. He surrendered. He was not arrested, but he surrendered voluntarily.
And then 119 days.
119 days, my lord. He cooperated, my lord. Charge sheet submitted, my lord. Charges framed. And he is awaiting trial, my lord. My only submission is that, my lord, he will face trial, my lord. There is no question of, my lord, he absconding, my lord, because, or he hampering or tampering with the evidence, because he hails from a different district, my lord. And all throughout the investigation, my lord, he has cooperated. He has voluntarily surrendered, my lord. So let him go on bail, my lord, at this stage, my lord. Because the question regarding abatement of suicide perhaps if he admit, regarding abatement, that is a subject matter of trial, my lord. He will face trial, my lord.
My lord, the incident is of 11/7/2025, my lord, on which date, my lord, the girl was taken to his house, my lord. She was kept the whole day, my lord. And after, my lord, he said he will not marry her, my lord. Then she returned, my lord. And in the night, my lord, she was abused. And also, my lord, she was threatened by stating that, my lord, her video and photographs will be viral, my lord. And on next day, my lord, she has committed suicide, my lord. So abatement part is, it is there, my lord, since my learned friend has already submitted, my lord. Charges have already been framed, my lord. That means, my lord, it is a matter, my lord, where, my lord, the evidence will have to go, my lord, because the complainant will have to, because the victim, she has already died, my lord. So let the complainant examine, my lord. So the abatement part is there, my lord.
But the question.
Complainant is father.
Father, my lord, because.
No question of him being influenced by the.
But he hails from a different district,
He
my
may
lord.
influence and he may also.
He hails from Dhubri, my lord. They are from Nalbari, my lord. And, my lord, he would never have voluntarily surrendered, my lord. He voluntarily surrendered, my lord, because knowing very well that he never instigated the suicide. There was definitely a rift between the two families regarding refusal of marriage. Let me complete. Regarding, my lord, the refusal of marriage, there was a rift between both the families. But that does not mean that he had directly done something for which compelled the victim to have committed suicide. These are subject matter of trial, my lord.
At this stage, my lord, I'm opposing, my lord, because this is evidence has not yet started.
Counsel for the petitioner and LPP. An application under so and so. As per the allegations contained in the FIR. Case 25, first paragraph. Subsequently, the petitioner had applied for free arrest bail, which was rejected by order dated 07/11/25 in AB 1899 of 2025. Subsequently, the petitioner surrendered before the police and was taken into custody. Investigation is complete, culminating in charge sheet, and charges have already been framed. In the meantime, petitioner has spent 119 days behind custody. Having regard to the above, the prayer for bail is allowed. That you write learned additional if he objects to the 50,000 one surety. Are further provided that the petitioner shall regularly appear at the trial and shall not try to influence or intimidate the witnesses in any manner. Petition stands disposed of accordingly.
Highly obliged, madam. Highly obliged.
My lord, I am sorry to say, your lordship, in respect of item 28, my lord, I may be allowed to go and appear. And this,
All right, item 28, had learned counsel for the petitioner and learned additional PP. It is stated that CS has already been submitted by so and so. Learned counsel for the petitioner submits that he would appear before the learned trial court and apply for regular bail. The sent application accordingly stands closed with the observation that in the event of the appearance of the petitioner and filing of any bail application, the same shall be considered as per law.
Charge number may be mentioned, well. Charge number 6/2026, dated 28/3/2026.
Bless you, lord. Myself.
May it please lordship. So a small quantity of cannabis was recovered lordship. Live 49 days behind the bar lordship. The co-accused person revealed my name and the petitioner was arrested.
31, my lord, case that is not received, my lord.
ইয়াৰ পৰাৰ কথা নাই আৰু লাইক বেইলত সেইটো
A small quantity of cannabis has been recovered lordship. Live 49 days behind the bar lordship. The co-accused
small
person-
quantity means technically small quantity or according to you small
713 gram lordship.
Huh?
713 gram lordship. Cannabis lordship.
Intermediate quantity.
No lordship.
Yes, PP. Intermediate.
Case that is not received today, my lord.
49 days lordship.
We will fix a short date, my lord, on today is second, my lord. We'll fix it on, my lord, 7, my lord, Tuesday.
All right, CD not receive list again on 7th.
I'm like that.
May please, your lordship. Lordship has heard the matter at length yesterday. My learned friend was supposed to produce some judgment which speaks to the contrary of the judgment placed by me, lordship. The judgment passed by Honorable Justice Borua, lordship.
Nothing, my lord, contrary, my lord.
Yesterday he has
It is seen at a different aspect, my lord, because I cannot say the contrary.
Learned friend
শব্দটো ভালকে দিবা।
Learned friend submitted that some judgment have been passed later on, saying otherwise, lordship.
May I please, your lordships? May I please, your lordships, my lord, regarding the principle, my lord, whether the filing of the charge sheet after within a stipulated period, whether it will be entitled for default bail, my lord. I am relying on 4 principles, my lord, that has come out, my lord. My lord, regarding the investigation part, my lord, it was done by my lord, police, my lord, and there, my lord, 60 days and 90 days, my lord, the time is given. And within the period of 60 days, my lord, and 90 days, if charge sheet is filed, my lord, then, my lord, there is no the right to default bail does not accrue, my lord, since the charge sheet has been filed, my lord. That is one thing, my lord. As per the simply, my lord, as per the honorable court's, my lord, interpretation also, my lord. Now, my lord, when my lord, charge sheet is filed on time, my lord, until cognizance, my lord, that is what this case is, my lord. Whether they within this gap period, my lord, whether the learned trial court has the power to remand, my lord, and also, my lord, whether he will be entitled to default bail if, my lord, within that period cognizance is not taken, my lord. In that case also, my lord, I'll place one judgment, my lord, authority, my lord, where it says, my lord, that if, my lord, charge sheet is filed in time, my lord, till cognizance, my lord, whatever reason, if it is pending, my lord, and there are remand orders were passed, my lord, then, my lord, there he will not be entitled for default bail, my lord, because it is with the ambit of the court, my lord. He is within the ambit of the court, my lord. That is one. That is the second, my lord. And thirdly, my lord, that if he has, my lord, another gap, my lord, whether within this gap period, my lord, whether he has prayed, whether there is a petition pending, my lord. In the Sanjay's case, also it has been made clear, my lord. After starting of the statutory period, my lord, right, my lord, until filing of the charge sheet, my lord, in that gap, my lord, whether he has filed any petition for default bail, my lord.
I think he had
No, my lord.
in this case.
No, my lord. That is what he has not filed, my lord.
Then so it is
No, I filed a petition.
Yeah.
I filed a petition seeking bail. Thereafter, learned court below has observed since charge sheet is late,
No.
I am not entitled to
That
bail.
is, yes.
That order I have
Yes.
annexed.
Whether
when is the date you filed your bail application?
Bail application date, Lordship.
it is, I have the in the
I have
healthcare
annexed.
vaccine, my lord, there is in after the, my lord, period of
After the later period, later
later
date.
period, at a later period, my lord. Not before charge sheet, my lord. Not before my lord charge sheet filed. And this is that situation is not to be questioned here, because, my lord, the charge sheet is filed on time, my lord. I am saying that if charge sheet is not filed from the start, from the date on which statutory period is extinct, my lord, within that period, whether there is an application or not, that is one part, my lord, that may not be taken into account in this case, because the charge sheet
After expiry of statutory period and before filing of charge sheet, whether the bail application has been
there,
filed.
that is also not there, my lord. That is one aspect, because if we assume also, my lord, if we say, assume that he has a right, my lord, that is also not there. That is what I want to, my lord, convey to the court, my lord. Because in this case, my lord, charge sheet is filed on time, my lord. That is one part, my lord. That will also not come. That is a third principle, my lord. And later, my lord, if he has filed a petition, since he is, my lord, because since he is making out a case that after the charge sheet, my lord, and before the cognizance, he is entitled to bail, my lord. Whether he has filed whether there is a bail petition. Yes, there is a bail petition. If his case has to be considered, my lord. Yes, there is a bail petition. But whether in that bail petition he has argued for the default bail or not, my lord. That is one part, my lord. And that aspect has been cleared by another judgment of this, my lord, Honorable Apex Court, my lord. If he has filed a petition seeking bail, but he has not argued as a default bail, my lord, assumption is that he has made his case for granting default bail, my lord. But in this case also, he has not pleaded before the court that he is right to default bail. That is clear from the
That a
record.
bail application is available.
After within, my lord, till cognizance, my lord, it is available. It is available and it is decided also. Decided and rejected, my lord. 2-3 dates have gone. He has not prayed that he wants to go on default bail, my lord. That is also not the case for him. So in lieu of all this, my lord, principles laid down by the Honorable Apex Court, my lord, he is not entitled for default bail. And simply, my lord, in first instance also, if your lordship may, my lord, appreciate, within time the bail has been charge sheet filed, my lord, and thereafter, my lord, within that period, though cognizance is not taken, he is saying that he is entitled for default bail, but the Honorable Court has made it clear, no, you have extinct your right because Salan has already been filed. That has been made clear in Sanjay Das case, my lord. I am reading one of the judgment, my lord. May kindly I'm just reading, my lord. Lordship, may kindly from paragraph 14, my lord.
And 90 days expires on 12/12.
12/12.
12/12. And so he becomes entitled on 13/12.
13/12.
13/12.
CS is dated 21/10.
21/10.
First put up is dated
31/10.
31/10.
TS is dated 23/9.
23/9.
21/10.
21/10. It was put up on 31/10. Within the 90 days period.
My petition was rejected on 18/12.
Cognizance was taken on
Cognizance was taken on, my lord.
8/1.
8/1. Finally come to para 14, my lord. The power of remand is vested in the court at the very initial stage before taking of cognizance under section 167(2) of CRPC. Once cognizance is taken, the power to remand shifts to the provisions of section 9 CRPC, under which the trial court is empowered to postpone or adjourn proceedings, and for the said purpose to extend the period of detention from time to time. Section 309.
which para are you reading?
Para 14, Lordship.
14.
Para 14.
Yes.
May I read once again, madam?
Yes.
The power of remand is vested in the court and very initial stage before taking of cognizance under section 167(2) CRPC. Once cognizance is taken, the power to remand shifts to the provision of section 309 CRPC, under which the trial court is empowered to postpone or adjourn proceedings, and for the said purpose to extend the period of detention from time to time. Section 309 subsection 2 CRPC contemplates a situation where if the court, after taking cognizance of an offense or commencement of trial, finds it necessary to postpone the commencement or adjourn any enquiry or trial, it may, for reasons to be recorded, postpone or adjourn the enquiry or trial on such terms as it thinks fit for such time as it considers reasonable, as may be warrant remand the accused if in custody for a period of 15 days at a time, madam. That is regarding 309 power, madam. And I am skipping the para 15 because it speaks of 309, my lordship is. Yes. Lordship, now kindly come to para 17, my lord.
Yes.
Para 7, it has been discussed, my lord. Para 17, perhaps the lordship is gone for. But in view of the grant of sanction, in our view, power of sanction is nowhere contemplated under section 167 CRPC. When the said section contemplates is a completion of investigation in respect of different types of cases within stipulated period and a right of an accused to be released on bail on the failure of the investigating authorities to do so. The provisions relating to remand of an accused first during the stage of investigation and thereafter after cognizance is taken indicates that the legislature intended investigation of the certain crimes to be completed within 60 days and offences punishable with death, imprisonment for life within 90 days. In the event investigation is not completed, the investigating authority, the accused, acquires indispensable right to be granted bail if he offers to furnish bail. Accordingly, if on either the 61st day of the 91st day accused makes an application for the releasing on bail, in default, the search sheet have been filed. The court has no option but to release on bail. The said provision has been considered and interpreted in various cases, such as my lord referred to as in the Natabar Pandey case and Sanjay Des case, were instances where search sheet was not filed within the period stipulated in section such and such, an application having been made for the grant of bail prior to the filing of search sheet. This court held that accused enjoyed indispensable right to grant of bail if an application was made before the filing of search sheet. But once the search sheet was filed, such right came to an end, and the accused should be entitled to pray for regular bail on merits. Right. That is the conclusion of paragraph 17.
Basically, it says filing is enough.
Filing is
Sanction,
enough.
cognizance, all
Yes.
these things are immaterial.
Immaterial, man. In paragraph 18, Lordship may kindly see paragraph 18. It is very much clear, man. None of the said cases distract from the position that once a search sheet is filed within the stipulated time, the question of grant of default bail or statutory bail does not arise. As indicated here in our view, filing of search sheet is sufficient compliance with the provision of section 167(2)(a) subsection 1 in the case. Whether cognizance is taken or not is immaterial as so far as 167 CRPC is concerned. The right which may have accrued to the petitioner had search sheet not been filed is not attracted to the facts of the case merely because sanction had been obtained to prosecute the accused and to proceed to the stage of 309. It cannot be said that accused entitled to the grant of statutory bail. So, for some reason, if the cognizance cannot be taken, the accused is not entitled for default bail within that period, since there is power under section 309 to remand. Relying on all these cases, my lord, another judgment was based on 2023-15 SC. Is this one?
Yes.
Another judgment, madam, it is 2022-15 STC, madam. Here also it has come out, madam, relying on all the other earlier judgments, my lord. It was kept intact. Thus, an accused held is not entitled to demand release on default bail under section 167(2) on the ground that cognizance has not been taken before the expiry of 60 days, madam. And it has held, madam. I am reading section para 27. I will hand over the copy, madam. A close scrutiny of judgments in Sanjay Dutt, Madar Sheikh, and Ravindran would show that there is nothing contrary to what has been decided in Bikram Chand's Jain case. Well, that is, I have given, my lord. In all the above judgments, which are relied upon by either side, this court had categorically laid down that the indefeasible right of an accused to seek the statutory bail under section 167(2) CRPC arises only if the search sheet has not been filed before the expiry of statutory period. Reference to cognizance in Madar Sheikh is in view of the fact situation where the application was filed after search sheet was submitted and cognizance has been taken by the trial court. Such reference cannot be construed as this court introducing an additional requirement of cognizance having to be taken within the period of prescribed under proviso A to section 167 2 CRPC, failing which accused will be entitled to default bail even after filing of search sheet. It is not necessary to repeat that Madhur Sheikh and Ravinder, this court expressed its view that non-filing of search sheet within the statutory period is ground for availing the right to claim bail under section such and such. The conundrum relating to the custody of the accused after expiry of 60 days has also been dealt with by this court in Bikramchand Jain's case. It was made clear that the accused remains in custody of the magistrate till cognizance is taken by the relevant court. As the issue that arises for consideration of the case is squarely covered by judgment in Bikramchand Jain's case, the order passed by the High Court is hereby set aside. Now going to the record, my lord. When we can say that M. Ravindra's case, my lord, that is, I have not given the my lord, citation, my lord. There one thing has been stated, my lord.
Which case?
M. Ravindra's case, that is, my lord, 2021 2 SCC 485, my lord, but I have not given them, my lord. Mention is there regarding the Ravindra's case, my lord. But what is stated, my lord? One thing is clear, my lord. If application for bail has been filed after the expiry of statutory period, if his case, assuming, my lord, if then application for bail has been filed after the period expiry of statutory period, and it would mean that accused has deemed to have availed of or enforced his right to be released on default bail. But here, my lord, he has not made any case in his bail application for releasing him default bail, my lord. So he has missed the bus at that time. Going by that principle also, my lord. I have flag marked the, my lord, this orders and the bail rejection order. The lordship will find from the order, my lord, there is nothing that he has paid for the default bail. There is. So in that case, my lord, I find in my humble submission that the filing of the search sheet and the order suggests, my lord, it was filed on time, my lord. So he is not a, my lord, entitled for default bail at this stage, my lord. That is my submission.
What about the other case?
Other case,
May I reply shortly, Lordship, in this case? I am relying on the para 38 of the judgment, which I produced yesterday, Lordship.
Yes.
That says compliance to 173(2) of the CRPC, corresponding to 193(3) of the BNSS. That is important, Lordship. Just because police submitted charge sheet dated so and so within the period is not sufficient, Lordship. That Lordship may kindly see 193(3) of the BNSS, the language, Lordship. That is where Lordship, that in context of that para 38 is very clear, Lordship. BNSS, Lordship may kindly see. Date of charge sheet is not important, Lordship. 193(3), as soon as the investigation is completed, the officer in charge of the police shall forward, including through electronic communication, to a magistrate empowered to take a cognizance of the offense on a police report. A report in the form of as the state government may by rules provide. That is the, Lordship. That compliance is required to be, Lordship, there. And in that judgment, the Honorable High Court has, Lordship, observed that merely putting up is not sufficient. It has to be, Lordship.
He does not say putting up is not sufficient.
Putting up, Lordship, but says that puts the initials in the charge.
It says filing in the office is not sufficient. It has to be
Yes,
put
not
up before
sufficient.
the magistrate.
Lordship, puts the initials in the charge sheet as well as the register, maintained with the date and seal of the magistrate. It would be that date on which the charge sheet has been deemed to have been submitted to the magistrate court. And Lordship is relying on this, Lordship, proposition. Our High Court has passed certain orders, Lordship. I would like to take a, Lordship. Short order, Lordship. My submission is that Lordship.
He is no different from the CRPC.
Yes, same.
Same provision is there.
172 is same, Lordship. My submission is that, Lordship, without the initial being there, without any register being maintained to that effect, that 173.2 compliance is not there. So therefore, the charge sheet was not there, would not be submitted to be filed in terms of 173.2. That's why my right to default bail comes, Lordship, in the absence of that, Lordship. In that, I have submitted just now, the learned, the Honorable High Court, coordinate bench has observed, Lordship. Lordship, may kindly see the last part. In the instant case, it is seen that the charge sheet has been just picked up before the court on 3/10/25 after the mandatory period is over. And the same, the order dated 3/10/25 does not show that the court has put the initials or the necessary stipulation is made in the register. As such, it is considered that the mandatory period was over on 29/10/2025. And before that, Lordship, this judgment was relied. Samsun Noor versus State of Assam, Lordship. 2022 5 GLT 405, Lordship. That initial, that putting up initial and maintaining in the register with date and seal. That is the, Lordship, sign on, Lordship. Whether, Lordship, that my learned friend has relied the judgment, I have no dispute, Lordship. Since one charge sheet is submitted, I have not filed any default bail petition, my right extinguished. But here, Lordship, what I am submitting is the charge sheet would have been deemed to be submitted on the day before the court, only after, Lordship, that this is complied. Initial as well as, Lordship, the maintenance of register along with, Lordship's date and seal, Lordship. That para 30 of the judgment is very clear, Lordship. Because this has not been done in the present case, Lordship, I am entitled to default bail, Lordship. This is my specific case, Lordship. I am not denying the ratio in the other cases, Lordship, Sanjay Dutt, Rabindran, Lordship. That is very much clear, Lordship. But this view has been followed by our High Court, Lordship, also.
If we have to go by the decision cited by the prosecution, we will have to say that filing is enough, because that is what is said in those decisions.
But here, Lordship,
Supreme Court decision will prevail.
In the judgment, filing, Lordship, that 38 says the filing is not sufficient, but that initial, it will amount to filing.
And also, my lord,
Only after this is done, this will amount to filing.
Also, assuming, my lord, if he has a case for default, assuming, my lord, for the sake of argument, whether he has availed of the right or not, that is very important.
Yes, my petition was there, Lordship.
Petition,
dismissed.
will not arrive, not my lord.
Where is your petition?
Because
my bail petition, although I have not argued on default.
Yes, although
my bail petition was there.
Have to argue on default. That is just very specific. Your lordship may kindly see what 167(2) says, my lord. My lord. And on the expiry of said period of 90 days or 60 days, as the case may be, on the expiry.
That is
the accused person shall be released on bail if he is prepared to and does furnish bail, and every person released on bail. So if he is prepared to, that is he has to show that he wants to default bail, man. That is, and that has been, my lord, observed in my lord, M. Robinson's case.
If there is an application, what does it say?
Yes.
If he has filed the application, what does it say? If it does not talk about default bail.
Yes, my lord. It will merit, my lord.
Merit.
Merit. That is what says, my 2000. That has also been cleared by the Honorable Apex Court, my lord. If we assume, my lord, but though it is not a case here, my lord. That is what.
Then, Lordship, item 10, Lordship, may kindly take. It will not take such time.
What is the on that point also you want to show something?
Yes, but it is a my lord regarding. I'll give the my lord citation, my lord. I have not taken the printout because that is not a case here, my lord. So I just have to, for the sake of argument,
Lordship, may kindly take up item number 10.
Yes.
Dates are defined. Case is, Lordship, of POCSO. Here I have filed the petition before the court below, seeking default bail. On that ground.
Because record has to be seen.
I have arranged the order sheet as well as the order.
Or that, my
All
lord.
order, Lordship. Lordship may kindly see for a moment, Lordship, whether TCI is required. If required, Lordship may kindly call for. In this case, Lordship may kindly say I was arrested. I was remanded on Lordship 16/10/2025. Thereafter, I have completed 90 days on 13/1.
Yes.
13/1/2026. And my right to default bail started on 14/1/2026. In the meantime, Lordship, charge sheet was dated 30/11/2025.
So long back.
Long back within time. But the court below has dealt that the same was put up before the court below on 8/1. 8/1/26. But that order does not reveal any endorsement initial on the charge sheet. Nor does it reflect that the charge sheet was entered in the relevant register with date and seal, signature of the court. Here I am only on that point of endorsement or initial, as laid in paragraph 38, Lordship. Then, Lordship, I filed a petition before the court below on 17/1. Lordship may kindly see page 38, 17/1. Specifically, Lordship, pointing out this issue, Lordship, default bail, relying on the judgment of our High Court, Lordship. Page 38, then order, Lordship, will start at page number, Lordship, 41. On the same date, it was disposed. 17/1/2026, page 41. Some judgment of the Honorable Supreme Court was cited. Operative part, Lordship may kindly see page 52. These are the conclusion, Lordship, wherein it has been held that administrative acts such as endorsement, initialing, registration, or assignment of case number are not determinative of the date of filing of the charge sheet.
So Bikramjit Singh clearly goes against you.
From Chand jail.
Page 45.
Bikramjit Singh says that the filing and taking cognizance cannot be equated.
Yes. Filing of the charge sheet is a mechanical act of presentation before the court, whereas cognizance is a judicial act.
Judicial act.
Moment the charge sheet is presented before the court, accused loses the right. So put up means presented.
That is
No application of mind is required.
I am only on that para 38, Lordship. If Lordship finds that I have some force on that, Lordship, then Lordship can decide. That my submission is that initialing, Lordship, or endorsement in the register is
All
required.
right, we are all trying to get to the bottom of the matter.
Yes, Lordship, yes. It's about, Lordship, that interpretation. Because the para 38 says, Lordship, that initialing is also important, Lordship. And maintenance in the register, Lordship. Cognizance is not required, Lordship.
But you have not, and you have annexed the charge sheet here.
Lordship, I have annexed.
In both the cases, in both the charge sheets, even now there is no initial.
Even now, there is no
So
initial.
that practice is perhaps not there in that court.
But
Whether
Lordship,
lordship is deciding the 10, item number 10.
10 can be disposed, Lordship.
Whether the
We'll reserve for judgment.
But whether lordship is
Ten.
TCR to be called for, or lordship has seen only that point regarding.
Lordship, TCM may not be required, Lordship.
Huh?
So,
TCR I don't think is required because these are admitted points.
Yes,
All are
admitted.
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 I am in the same that I am argument my same.
Yes, same argument.
And just one point I have missed out on that judgment I have given my lord. It's a three-judge judgment decided by three judges bench.
Three judge bench. Which one?
That becomes Sanjain, my lord. First one, my lord. That is 2013 PSCC 77. Decided by my lord Justice.
Suresh Bikram Sanjay, okay.
First. I'm deeply obliged.
Obliged.
AB.
Deeply obliged.
Lordship, I beg to mention item number 34, Lordship, to adjourn for the day, Your Lordship. As my senior could not come to the court due to some medical issues.
34.
Yes, sir.
Give it date.
Kindly fix it on Monday, Your Lordship.
exists there. Because from arrested here and we have to inform in Manipur. That is one thing. They have been duly intimated over. This is also there thereafter that has been settled. $10.858 kgs of
Where is the notice you have all subsequently sent? 48 notice.
48 notice, Lordship, they have annexed it here. Page 53. Five.
How was this sent?
God. This has been intimated by telephone, which right by the petitioners.
No. So your persons will know how they have sent this notice, by what mode. None appears for the petitioner. Representing NCB, Mr. A.D. Chaudhary, obtain instructions as to the mode and manner in which the notices under section 8 served annexed to the instant bail application were served upon the family members of the petitioners. List the matter again on undue need.
Lordship, in item number 33, the CD is not available. The CD may be called for.
Purva, several days have gone. He's enjoying benefit of interim.
Interim is there, my lord.
That is what we are saying. He's enjoying the benefit of interim and CD is.
Well, we have also my lord, sent request on several occasions, my lord. Some may be given, my lord.
Where is this from?
This is from Murazar, my lord, Hosai.
Not received. Since 1911-25, the OC. Is this Musazar?
Murazar, my lord.
Murazar, M-U-R-A.
Murazar.
Murazar Police Station. Hojai, this Hojai is directed to ensure submission of the CDA on the next date fixed. The matter again on
28/4.
interim be continued till the next date.
Yes, my lord, otherwise the interim was granted on 27/2, but till my lord 13/3 they have not appeared, my lord. Till 13/3, we got the CD on 13/3, they have not appeared, my lord. Interim was granted on 27/2. Around 50 kg of suspected fake gold was seized from the co-accused. And from their statement, he stated that he has purchased from 2 persons. And why these 2 petitioners is apprehending, my lord, investigation is going on. It is not very clear, but otherwise interim was granted on 27/2. They have not appeared, my lord.
Date was also fixed
Yes,
to appear on 6th of March.
we have received the CD on 13/3, till 13/3 not appeared. Report.
Yes.
Lordship, Passover maybe that's requested.
But
I think-
Passover in second half.
Time being.
Thank you.
May I please the lordship? So in this matter, case day was called for lordship. Lordship will find that FIR at page 11, lordship. May I read the FIR, lordship?
Yes.
The informant respectfully begs to state that on last 21/5/2025, at about 12 noon, my daughter, namely so-and-so, aged 17 years, was missing while going to Lahorigat Rajagadua Senior Secondary School. I searched for my daughter but could not find her. On last 22/12/2025, my daughter reached home, and after being asked her, came to know that the accused number 1, with the help of accused number 2, kidnapped my daughter and kept her in Kerala. On last 22/12/2025, the accused number 1 took back my daughter from Kerala to his house and beaten her. She escaped and reached our home, and accordingly we came to know about the incident. There is delay in lodging the hazard as we were busy with the treatment of our daughter. We came to know from the daughter that accused number 1 solemnized marriage in Kerala. Lordship, I am the accused number 2, Lordship, and the alleged incident took place on 21/5/2025, and the FIR was lost on 23/12/2025 after almost 7 months, Lordship. And
my lord, may peruse the statement of the girl, my lord. He is the elder brother of the main culprit, my lord. and he helped his brother along with that girl to federate to Kerala. My lord, as per the statement, 183 statement. My lord.
And Lordship will find page 16, one declaration by the
Girl is major.
17.
per FIR, Lordship.
17 years.
Lordship will find at page 16, one declaration by the parents, Lordship, of the girl for solemnization marriage, Lordship. Page 17 is a marriage
His
agreement.
certificate has been collected by the IO.
17 is a marriage agreement, Lordship. Though it is not legally tenable, Lordship. Page 17, I have annexed, Lordship. Main allegation is against the accused number 1, Lordship.
He is Hibzur and main culprit is Akamul.
My instruction is that presently girl is with the accused number 1, Lordship.
Not pothai diye. You went willingly. Yes.
First, number 2.
Huh?
All in the incident 1. Or 1. Okay.
They must be in a relationship, otherwise she would not have gone with him. Did not. Heard learned counsel for the petitioner and learned additional PP also heard learned counsel representing respondent number 2 decision application under so and so. The allegation as per the FIR is that the victim girl aged about 17 years went with the accused number 1 Akmal Haq to Kerala and hence an FIR was lodged by the father of the victim alleging that his daughter was kidnapped by the accused number 1. Subsequently, the victim girl, she came back on her own or she was brought from
On her, Lordship. On her.
returned on her own, and subsequently her statement was recorded by the magistrate. Here's from the aforesaid statement the victim that the present petitioner, who is the elder brother of the accused, did not play any role other than sending a couple to Kerala. Regard to the nature of the allegations, custodial interrogation of not be necessary. Accordingly, the prayer for pre-arrest bail is allowed. The petitioner, in the event of the release, the bill of rupees 50 security for like amount. Section of the arresting provided that the petitioner shall appear before the IO in a period of 10 days from today. Shall not try to And cooperate with the investigation. Added that petitioner shall not try to state the witnesses. Hence disposed of accordingly.
Sublime.
In 36.
Please, Your Lordship. Lordship 482 BNS's application, Your Lordship. Your FIR is case number 10, Your Lordship. Type copy of the FIR, Your Lordship. The allegation is that, Your Lordship, some accused persons, Your Lordship, some golden biscuit has been recovered from a vehicle, Your Lordship.
According to the CD, you have not appeared before the IO.
We appeared, Your Lordship. We appeared. As per instruction, we appeared, Your Lordship. They appeared.
Till 13-3 not appeared, my lord.
But as
When
per
did you appear? All right.
I take instruction today itself, Your Lordship. They told me they appeared, Your Lordship.
Learned counsel for the petitioner.
Then the report from the IO, my lord, regarding.
Written report
Yes, my lord, they have not appeared.
and learned additional PP. Additional PP submits that he has received a written report from the IO stating that the petitioner has not appeared pursuant to interim order passed by the court till 13/3/26. Full stop. On the other hand, learned counsel for the petitioner asserts that the petitioner has appeared before the IO and seeks time to obtain instructions as regards the date on which she had appeared. Place the matter again on 7th. In order to enable learned counsel to obtain the necessary instructions. Learned additional PP may also obtain further instructions in this regard. List again. 7.
Later may be taken after some time.
38, otherwise, my lord, TCR confirm, my lord, and here, my lord, POCSO matter regarding service.
Service is-
Not complete, my lord.
This is the point of passing for the time being. PCR not received. Service on respondent number 2 also not complete. List again on.
Our office noted 7/3/20.
Steps received.
Steps, that is steps, service
received
is
by
not
the
complete.
registry. But thereafter, it 11/3, thereafter, ma'am, around 15, it has been sent from our office, my lord. We'll take instruction, my lord, together. TCR also not received. 39. It a delay, that too. My lord, in 39, my lord, I was seeking another date, my lord. CD will not receive.
Same order. Have you taken steps on respondent number 2?
Yes, my lordship. We have taken steps.
Counsel for petitioner. And additional PP submits that it and seeks another date. Counsel enters appearance for respondent number 2.
Worship, we have not filed our Wakalatnama yet.
And is going to file Wakalatnama shortly.
We have objection, we will file objection also.
Is the matter again on so and so in the respondent number 2 may file objection.
Bless.
No. By page, Your Lordship. Malad, this is a substituted case under trial case. Malad, we are filing this PRS bail application. Malad, FIR is page 20. Malad, 11 portion. Malad, I would like to read out. May I read, Malad?
Yes.
I would like to inform you that the complainant, page 20, third parameter. I would like to inform you that the complainant company booked materials under its consignment notes for its various customers, which was to be transported from Pamohi Gorsuk, Gauhati, Assam to Aizawl, Mizoram. The complainant company approached Mr. Raj Bharve, proprietor of MSC Ganesha Transport, having his office at NH 37 Lalmati, Prakash Kanta Beltola, Gauhati, so and so, to provide vehicle to the complainant company. On dated 14/4/25, Mr. Raj Bharve provided a vehicle bearing registration number so and so, owned by Mr. Asmat Ali, son of Mr. Kalimuddin Sheikh, resident of Kawatika Bijli subdivision, Sirang, Assam, mobile number so and so, to the complainant company. It has been stated that the financial freight amount for transportation had been settled between the complainant company and Mr. Raj Bharve for the amount of rupees 55,000. It is stated that out of 55,000, an advance payment of rupees 45,000 was transferred to Mr. Raj Bharve. The balance payment amount 10,000 was to be paid at the destination point after we are delivering the goods in okay and proper condition. White lorry hire salan number so and so, dated so and so. The materials having value at 14,055 were loaded into the aforementioned vehicle and entrusted to the broker Raj Bharve, the vehicle owner cum driver Asmat Ali, who is the present petitioner, for safe delivery at the destination point. The vehicle with the loaded materials was ready to be dispatched on 14/4/25 to its destination point. The vehicle was being driven by Mr. Asmat Ali. It is stated that despite making the aforementioned advance payment to the broker, Raj Bharve, proprietor MSC Ganesha Transport, the aforementioned vehicle with materials has not reached its destination point in the stipulated time. This is the FIR, my lord, and allegation against me, owner cum driver, present petitioner, my lord. I have stolen, committed theft of the loaded articles of my vehicle, my lord, worth amount 17,14,500. This is the basic allegation, my lord. In support of my case, my lord, first of all, I'd like to submit, my lord. Actually, in para 6, I have stated the entire facts of this case, my lord. This is long, but I'd like to, my lord, read out the paragraph 6, my lord, subject to loss of permission, my lord.
Yes.
That the petitioner begs to state that he is the owner of vehicle AR01SC6078, model number so and so, chassis number so and so, engine number so and so. 1/14/25, he has loaded goods in the said vehicle from Sri Ganesha Transport, Gauhati, and started his journey from Gauhati to Aizawl. During his said journey, burst 4 tires of the vehicle one after another. As such, at that time, he is suffering from financial constraint and he has no money to purchase the last burst tire. After that, the petitioner asked the transport owner to pay his rent in advance, but the transport owner denied to pay the same. Under such circumstances, he parked the vehicle in safe and good parking place within the jurisdiction of Kalasan outpost near the National Highway, Lamding Silchar Road, and returned home. He was duly informed Sri Ganesh Transport. This line is important for me, my lord. He was duly informed Sri Ganesh Transport about his return home and also sent the exact GPS location of the vehicle. Vehicle was parked in front of the Line Hotel and nearby other shop was also there. And I have also informed to the owner of said hotel and shop about difficulties. From the petitioner house to place of occurrence is distance almost 500 kilometers, as such unable to return at the place of occurrence shortly. Therefore, before his reaching, the petitioner came to know through Sri Ganesh Transport about the missing of his vehicle. Later on 1/5/25, Kalasan police found the vehicle in accidental condition at the foothill area about 6-7 kilometers away from the parking place and informed him. In this regard, immediately after coming know about the missing vehicle and goods, he lost information regarding the incident before his local police station, namely Bijni police station, requesting necessary action and forwarding the same to the competent police authority having jurisdiction.
However, in the FIR, petitioner, due to lack of knowledge about the proper name of said outpost, wrongly mentioned Kalasanpur instead of Kalasan outpost, my lord. Instead of correct name Kalasan outpost, as such, said FIR petitioner not reached at the concerned outpost in time. Hence, the police authority till date not able to take any action against the petitioner's complaint. But this is my submission in support of my case, my lord. Now, I would like to refer, my lord, RC of my vehicle, my lord, Annexure 8, page 48. Here is, my lord, mentioned date of registration 29 November 2024. This is almost a brand new vehicle, and vehicle amounts are, my lord, a 6-wheel truck, more than 30 lakhs, my lord. And as on today, my vehicle laying in the accident place, almost damaged condition. And it is, I am trying to submit before this honorable court. It is logically not possible, logically not believable that in order to getting a theft of 17 lakhs, I have damaged my vehicle by amount almost more than 30 lakhs. So, my lord, I am trying to submit before this honorable court after getting the GPS location of my vehicle by said traders, transporters. He had committed this entire incident and subsequently blaming upon me, my lord. In this case, my lord, now charge sheet submitted, trial started. At this stage, my lord, no chances of tampering or hampering, and I am ready to cooperate with the trial proceeding, my lord. Any condition, my lord, I may be allowed to the APR before the trial court and face the trial, my lord. This is my humble submission, my lord. My vehicle is still in the laying in the accidental place, almost full damage, my lord. Myself is the victim by this case, my lord, also.
In the start sheet, he was shown as absconder, he was not found, not cooperated the police authority, my lord. And last order I have seen in the record, my lord, 10/3/26, it is still in the stage of appearance and copy.
Yes, sir.
Fixed on 28th of April.
April, my lord.
Now, my lord, witness stated that, my lord, vehicle, no goods available, even the battery of the vehicle also not available. So, my lord, exactly who has done this, that is suspecting that the, my lord,
Look at your conduct. You were the driver, you were in charge of the goods, and you left the vehicle without any proper custody.
Yes.
How is it
That is
believable?
That is true, my lord. But due to some, my lord, actually, I am also belongs to the very poor family background and also
Yeah,
remote
very
area.
poor family with 40 lakh truck.
My lord, I have purchased through finance, my lord.
Yes,
Just
very good.
giving down payment
Who
some.
purchases out of his own pocket?
My lord.
Think of, my lord, four tires one by one is not also
All four tires burst.
Is still my vehicle laying in the accidental area, my lord. So any condition, I am
get
ready to face the trial, my lord.
Insurance.
And in that trial, everything will reveal, my lord.
Thing will reveal in the trial.
My lord.
Because if you were so innocent, you could have cooperated with the investigation.
One point
You
I would like to
avoided
submit.
that.
During investigation also, this offense, maximum punishment is 7 years. During investigation also, my lord, 35B BNSS notice also not served upon me, my lord. And this notice also not served upon me, my lord. At any condition, my lord, I am ready to appear before the trial. And after getting some protection, I am also ready to file another case, my lord, in connection with that accident, because, my lord, I have to suffer much more monetary loss also, my lord. I have to pay to the finance company 30 lakhs, my lord. So in that regard, I have to take steps also, my lord. After getting some protection, I would like to proceed on that. My lord. Notice under section 35 BNS is necessary, my lord. It's mandatory, my lord. If offense is
because
not
my
more
lord,
than
leaving the vehicle in an abandoned condition and bursting of 4 tires one by one, these two things are not believable, my lord.
Really,
one or two may be accidental, my lord.
but another thing, my lord, I am the registered owner cum driver, and in order to getting benefit of 17 lakh, why I have lost my 30 lakhs?
Your vehicle not insured?
The insured, my lord, insured will not cover me, because if liability lies upon me, why insurance will give, my lord, compensation, my lord, claim?
That is the question you should answer. Why did you leave your vehicle?
My lord, there is some under some.
There is no plausible answer for that.
Under such complex,
Unless you have stolen the goods, there is no plausible answer why you would leave your vehicle there and go.
under such compelling circumstances, my lord, in order to
There
arrange
is
money.
no compelling circumstances. So 4 tires burst one by one. And this is not in the middle of the jungle that you have to run away. Admittedly, there are shops and it's a populated area.
Oh,
You could
near
have
one
shot
live hotel, my lord. I have parked my
And
vehicle.
500 kilometers away, you went home and sat doing
And
nothing.
I have sent the GPS location and entire details to the my transporter. And transporter also, my lord, accused in this case, my lord. State transporter Rajbhar also accused in this case, my lord. And I am trying to submit, my lord, state Rajbhar some committed this offense, my lord. And
The another truth, malad, he, malad.
yes, my lord. During trial, it will, my lord. Now I am, my lord, so far, my lord, investigation is completed, my lord, and no chance of tampering and hampering, my lord. Any condition, my lord, some protection may be given, my lord, I would like. I am ready to appear, my lord. Is that trial, my lord?
Nothing has been recovered, I think.
No, nothing, malad. No goods recovered, malad. Then the battery of the vehicle also missing, malad.
Now almost 200 meter, I think, down from the road, vehicle is lying, my lord. Hills area. And no possibility to, easy possibility to take to recover the vehicle from that position, my lord, place, my lord, accidental. Hundred feet down, I think, per my information from the road. Still laying vehicle there. Initially, this FIR was lodged before the Gorsu PS. Subsequently, it was transferred.
Transfer application. Police officer states that the truck was found overturned.
Yes.
The truck was found overturned from the hill in George Valley.
Around 200 or 300 feet down.
From
the road.
Some spilled materials were also found near the truck.
if some materials is there in the truck, that is also not easy to recover because accidental places much more down from the roadside.
Both of them are absconding. Is it? Are both the accused absconding?
Yes. No, my lord. Actually, accused number 2, Raj Barbe, against whom, my lord, in the charge sheet, IO submitted no, not to proceed against him. Only
Rajbarba is the broker,
broker, my lord.
But he was not in the truck,
But court sumoto taken cognizance against him, Raj Barbe. But in the charge sheet, police not, my lord. During investigation, I have seized. In the charge sheet, investigation officer says that prima facie only established against the Asmat Ali, present petitioner. But court has sumoto taken cognizance. And during investigation, the FIR name against the FIR name accused, my lord, I think also not interrogated him also, not called him also. Without calling and without interrogation, police submitted charge sheet and
They were not found in your home. They had gone there.
my lord. No, my lord, I am saying about Raj Barbe. In the charge sheet, investigation officer, my lord, not make any allegation against the accused Raj Barbe. And during investigation, without interrogation, without my lord, calling said accused, FIR name accused, charge sheet not submitted against him.
Media reports also connecting you.
Hello. I am only submitting, my lord. So far, investigation is completed, my lord. No chances of, my lord, tampering or hampering, my lord. And during investigation, my lord, no notice was served upon us under section 35 BNSS, my lord. On this two ground, I am seeking some protection, my lord. In the charge sheet, without interrogation, without calling a FIR name accused, discharging, my lord, not submitted a charge sheet against.
They had visited your place. They could not. You could not be found. If
Yes,
you were
yes, I am
found,
still
they
I
would
am
have
out of.
submitted the notice. But we'll see.
I'm obliged.
Please alert, sir. Service has been completed. Maybe fixed admin.
Yes.
It's not yet complete, Milan.
That's record of person.
Huh? Complete, no?
Completed.
Oh, sorry, service completed, Milan. Record, no?
Nine.
Our learned counsel for petitioner
Maybe
service
fixed for
on
admission, Milan.
respondent number 2 is complete. Objection file.
No, no.
But
Service completed. More question.
where is it given? Service is completed.
Well, he has said it. I have not checked, Milan. Some note flag X, Milan. Second file to substance.
Not received.
PCR of assist.
Has yet been not, they forgot the word not. Yet been received back from the district magistrate Nogam. Be not, I think.
In second file, Milan.
Service report on respondent number 2 is complete as per communication from the office of the district magistrate. Shankar Devnagar. However, none appears to represent the respondent number 2. What case is this?
For the search sheet.
Asking for Sasid, this 419, 468, 471.
Place the matter for admission on.
Visual option. It's a application under section 430 of BNS matter. And appeal is, it's a jail appeal actually. Later I was engaged, my lord. So here in this case, my lord, I was convicted under section 4 of POCSO Act, my lord, an imprisonment of 10 years, my lord. This stage, my lord, I'll be making submission on only two grounds, my lord, because this is an for bail only under 430 BNS. So
the records been received. Yes.
PCR is there, my lord.
Yes.
So, my lord,
appeal is admitted.
Yes, my lord. The appeal is from 2022, my lord. IA was filed on 2025 because earlier it was, my lord, that legal service was there, my lord. Thereafter, I was engaged, my lord. So, my lord, on 27/3, my lord, or just 6 days ago, my lord was pleased to pass on judgment, my lord, for cruel Islam. And in that judgment, my lord, that it was observed that benefit of doubt on age must favor the accused, my lord. Here in this case, my lord, it is also identical, my lord. If my lord come to page number 24, 23 and 24 of that of my application, my lord. 23 and 24. Page number 23, para number 15.
The relevant portion is at page number 24. Lordship will see that point number 2, my lord.
Yes.
Approx age of the girl is 18 to 19 years, my lord. One more aspect, my lord, that out
How
of
this
10
how was the age of the girl decided?
my lord, they have submitted one birth certificate, which was also, my lord, procured at
So
the
some
latter
other
stage.
thing is there.
Yeah, birth certificate, it is exhibited.
No, but that was, my lord, procured at the latter stage, my lord, and in that regard also, my lord, I'm relying one, my lord, judgment passed by the coordinate bench of your lordship. And my lord, out of 10 years, my lord, almost half of the period, my lord, 4 years, 5 months, my lord, he has spent behind the bar, my lord. So in regarding I'm placing the judgments, my lord.
Did not challenge the birth certificate.
Yes, my lord, during trial it was not challenged, but my lord,
Then
but I have placed one judgment, my lord, upon Kosari, my lord. Relevant para is 34, my lord. There are 29 also, my lord, which has discussed, my lord, relevancy of that, my lord, birth certificate.
what is the infirmity in the birth certificate according to you?
My lord, it was procured after my lord, in the year I think 2015, my lord. It is in the record. I have flag marked, my lord. It was
Before the
procured in the
occurrence?
latter stage, my lord.
Before the occurrence?
But my lord, it was not procured during the my lord, during her birth. It was later.
May not be. But at that time the incident didn't happen, so you cannot say that the age has been made up after the incident took place.
Though it was not my lord challenge, but
many people obtain birth certificate later on when the necessity arises. What is your date of birth?
8/10/2022, 2002.
002.
10 years, addresses, 9 months,
It was obtained in 2015.
15. And the incident of my lord, 19.
That has no connection.
No, absolutely, my lord, no.
apart from this, my lord, her age was by the radiology, my lord, doctor, it was my lord 18 to 19 years. And it's contradictory, my lord, in the statement.
Who
also,
has
my lord,
issued the birth certificate?
my lord,
Is it as per the Gazette Act?
Yes, it is regarding a flag, but the record it is there.
That is government.
Government. There are 26 of the judgment. The trial court has dealt with it, my lord.
Hmm?
Page 29, para 26 of the judgment regarding age part, my lord.
Yes.
It has dealt with the age factor, my lord, and decided that it is 16 years, 9 months at the time of occurrence, my lord. There is no challenge to the birth certificate, my lord. It was exhibited also. That part is gone, my lord.
Regarding that, my lord, the Topon Kosari in the judgment, para number 29, my lord, has discussed a similar case, my lord.
Other case. All depends on the facts of the case.
One more thing, my lord, in 164 statement also, my lord, some contradictory person is there, my lord.
In this case, Fakhrul Islam, there was no other evidence except the medical radiologist.
But my lord, that age factor is there, my lord. Basic thing is that, my lord, radiology department
That is
clearly
what.
stated that 18 to 19
Yes,
years.
because there was no other birth certificate or school certificate. That is why we said that this is 2-year margin has to be applied.
My lord, in this regard, my lord, that similar situation was discussed under this Topon Kosari, my lord, that para number 29. During hearing of the appeal, my lord, these things will definitely come, my lord, but this is, my lord, bail under 430. And my lord, where out of 10 years, my lord, almost half of the period he has spent 4 months, 4 years, 5 months, my lord. From her evidence and 164, my lord, it appears, my lord, that she was consenting party, and apart from this, my lord, she knew the accused, my lord, as a friend, my lord, and they used to perform together, my lord, to more dance, my lord. And in 164, she first said that she was taken to tea garden. Later, my lord, she changed her version to and said she was taken to Jahasville. So contradictory statements are there, my lord, in various aspects. Lord, regarding my second ground, my lord, that he has spent 4.5 years, my lord. I have submitted one, my lord, apex court, one with Kashmira Singh, my lord, 1977 for SCC 291. Kashmira Singh versus State of Punjab. Relevant para is para 2, my lord, in Kashmira Singh. Apart from all this, my lord, the appellant has his age-old mother only, and no one is there, my lord, and she is also bedridden now.
We can hear it immediately after Bihu also.
No, sir, that can be, because otherwise, my lord, so far evidence are concerned, my lord. The humble submission, there is no ground for suspension, at least at the.
After 4.5 years, my lord, almost half of there is clear ruling, my lord, of the apex court, that half of this few months.
Sentences for what? 10
lord,
years.
10 years. Almost half of the period he has spent, and my lord, the contradiction part is there, my lord. It is apparent. But my lord, that even in we rely, my lord, Kashmira Singh, that is para number 2, my lord, that at least, my lord.
Yes, what is it said in Kashmira Singh para 2?
My lord, may I read?
Yes. Paste it somewhere.
The appellant contains in this application that pending the hearing of the appeal, he should be released on bail. Now, the practice in this court, as also in many of the high courts, has been not to release on bail a person who has been sentenced to life imprisonment for an offense under section 302 of the IPC. The question is whether this practice should be departed from, and if so, in
That we have already departed from.
my lord. The letter part is relevant one, my lord. Though paragraph is long, my lord. I'm coming to that, my lord. In that circumstance, it is obvious that no practice, howsoever sanctioned by uses and allowed by time, can be allowed to prevail if it is operate to cause injustice. Every practice of the court must find its ultimate justification in the interest of justice. That the practice not to release on bail a person who has been sentenced to life imprisonment was evolved in the high court and in this court on the basis that once a person has been found guilty and sentenced to life imprisonment, he should not be let loose so long as his conviction and sentence are not set aside. But the underlying postulate of this practice was that the appeal of such person would be disposed of within a measurable distance of time, so that if he is untimely found to be innocent, he would not have to remain in jail for an unduly long period. The rationale of this practice.
23rd April, top of the list. But not with you. You are amicus. Okay, registry is directed to furnish copies to amicus.
My humble prayer, my lord. Till then, my lord, I may be released because, my lord, my mother is my lord bedridden now, and no one.
What is the point of fixing early hearing? We are to release you. We are hearing you within 20 days. List on 23rd.
The paper book is not ready. But in this case, paper book is not ready, my lord.
Paper book, is it necessary? Everything is in English. Yes, notice.
We have already taken steps.
Private notice, service of notice. Private respondent. Just again after.
May it please the lordship. Lordship, we have filed an interlocutory application for early hearing of the criminal revision petition, which was filed in 2022, my lord. My lord, the factual matrix of the case was that the present appellant lended 6,50,000 rupees in the year 2015 and 16 to the opposite party. And opposite party, while returning this money, he has given us the check that was dishonored, and the trial court as well as the appellate court passed the order in favor of the present applicant, my lord.
All right, when do you want?
Lordship, can it be on 29 or 30 of April after Bihu?
Like 30th of April, IA. 279 of 26 are learned counsel for the parties. This is an application for early hearing of the connected criminal revision. Prayer is allowed, list the matter on 8th of April. I stands disposed of accordingly. List the connected revision on
Oblige your lordship.
revision to main to yes.
But see, moot question perhaps which falls for a lordship's consideration is courts below have proceeded on the assumption that since the accused, now the convicted person is the beneficiary of the forged document, therefore he is the person who has forged. In my understanding of the matter, and I'm relying on a few Supreme Court judgments, even if somebody is a beneficiary of a forged document, unless it is established with evidence that he is the person who has forged that document, then he cannot be held guilty for committing an offense of forgery, Your Lordship.
Before my learned friend proceed, my lord, may I submit one thing, my lord? Here, my lord, opposite party, my lord. Appearance is necessary, my lord. Whether my lord service has not been completed, I have gone through the record, my lord. Actually, my lord, the paper book has been prepared, my lord. So a copy of the same may be furnished to us, my lord, and another that may be fixed, my lord. Can also go to the paper book.
All right. Heard. Learned. Amicus.
Yes, Your Lordship.
Mr. Keep amicus for the petition. And submits that a copy of the paper book may be to him to furnish the
Copy may be furnished to me as well, then.
As well as to learned amicus. What about respondent, private respondent? Who is the private respondent?
His name is Sri Sarat Chandra Das. He was the complainant.
The dispute between the two parties, my lord. And they are, my lord, whoever I have seen, my lord, they are the brothers, my lord.
Regarding a gift deed for an ancestral land, which was said to be executed by another sibling after his death. That is the allegation.
But are we sure if the person is alive? This is a matter of 2009.
2000, my lord, revision has been preferred, well.
Matter is of even earlier.
17 years back.
I think we should obtain some information because otherwise.
Complaint was filed in 2007. Original complaint.
There must be a reason why the person petitioner has not appeared. It is further noticed that due to non-appearance of the petitioner on several dates, learned amicus has been appointed to represent him. The original case is of the year
2007.
2007 and the present revision is of the year 2009 and 17 years have elapsed since then. Therefore, it would be appropriate to report from the C of the concerned PS regarding the present status of the petitioner. Accordingly, call for a report. the OC is Pachala.
This is Patsala. Bozali Patsala.
Pachala PS Bozali.
PS will
I
be
think Patasar
Patasar.
PS. Patasar is now Borpeta or Bozali. Bozali, I think. As to whether the petitioner dead or alive looks bad, will say whether the petitioner is still available to prosecute the case. Both petitioner and respondent number 2, Sharat Chandra Das. Bharat Chandra Das and available to again on
Deep leverage.
The crossing application minor, in a case of defamation minor. Regarding a newspaper publication in a Home Prohibition minor. The proprietor, chief editor, printer and publisher, executive editor, the accused person minor. And they be this item is relating to former Congress MP Moni Kumar Subba minor. Was involved in a rape case minor, and the respondent minor what he appeared as a broker minor, and he what happened, he has understandably, surreptitiously to a mobile phone, my lord, camera, spy camera, recorded a conversation with the informant. So
he is appearing for other side.
Yes, my lord, name has been shown, my lord, but
okay, let's put up after view. Okay, learned counsel for the petition, and however, here's for the respondent, although name is was list. The matter again on Bihu.
interim order, may not. Interim order is there.
Interim order passed earlier to continue. What are all these cases?
Transfer petition law. Transfer petition seeking transfer from an NIA proceeding from Odalguri to Mogalgoi. All the connected matter lawsuit.
Odalguri to Mongoloi.
Yes.
Petitioners are same.
Petitioner is same, but the respondents are different. In appearing for respondent file, in item number 50, 51 and 52.
6 NIA case, my lord, they want to transfer from Odalguri to Mongoloi, my lord. I think that they are threatening.
Odalguri to Mongoloi is not very far.
64,
what is the
64 kilometers. Now,
is there any I mean,
yes, there was some threat perception. Yeah, the petitioner was given threat for making payment and not to adduce any defense evidence. Accordingly, he informed the matter to police station also. Now, the petitioner, the accused petitioner, he was a contractor a work order was issued in his favor. After executing a portion of the work, somehow he could not manage to do the entire work. So he engaged the petitioners, the complainant. And there was a power of attorney executed between the complainant and the accused that they will complete the work left out. And after that, they will place the check. Now, without completing the work, they have placed the check and that was dishonored. Now, I need to examine the witnesses from Irrigation Department of Mongoloi Division to prove that without executing the work, they did not complete the work. So I need to take them to Udalguri. And because of this threat perception, they are not willing to go to Udalguri. And secondly, the petitioner is a aged person. He has undergone operation also. Now, 64 kilometers, Mongoloi, Lordship, or any other convenient place.
Regarding the threat, there is an additional affidavit in item number 49. The file, there a GD and FIR was there, and it was made a GD entry. Regarding the GD entry, alia, Honorable directed me to take instruction whether such threatening or not. I have wrote letter to the officer in charge of Udalguri PS December, and subsequently I have talked with the OC also, but he stated that yes, GD entry they have found, but within the court premises, no such nothing has been found. And if at all, this is of 2023, if now any threatening, they may take police protection or they may complain. Otherwise, within the court premises,
Petitioner approached the IO, the officer in charge, for seizure of that CCTV footage, but they did not do that. Out of several requests, because adjacent to DC office, the court premises is adjacent. In both the premises, there were CCTV installed, and he was asking the officer in charge to seize the CCTV footage to prove the allegation that he was subjected to threatening.
May I please, Your Lordship? The incident took place on 1912. 1912, in the premises of the DC campus, just adjacent to the learned CGM court. The petitioner before Your Lordship appeared on that particular day while you after yes, an affidavit, I'm returning back. His is that the two unknown person threat not to come before this further. That happened on 1912-2020. FIR filed 2012-2023, No explanation, delay explanation mentioned, and it is an afterthought, If reasonable person cannot believe, while the DC office and the CGM court is they have not reported, the petitioner has not brought any particular allegation on that particular day, And while next date was fixed for off of the DWs. On that very day, he filed this allegation. And that was done. I have filed my affidavit, And for that the NIA case is pending, There is a stay order.
Cause of action has actually become stale now with the passage of time.
That's
police also said that the GD entry is there, but for record,
if needed be, he may be given protection, sufficient protection that observation may be made if it is required.
Heard learned counsel for the petitioner. Heard learned presenting the private respondent along with learned additional was referred in on an allegation that the petitioner herein was threatened by the other side.
Unknown
To
person.
unknown person.
From by unknown persons. A view to prevent him from effectively prosecuting his case, which was pending before the
Garnet CGM Dalguri.
CGM Dorong Mongol.
No.
Oh, sorry, Udalguri.
Udalguri. Alleged incident is of what is the date of incident?
In 12 to
1912 and 7/2. Two incident.
In 12
And
23.
23.
And 7/2/24.
In this regard was made on
20/12/2023.
Next
day.
next day.
Next day.
However, long time has elapsed since then, and the situation on the ground may not have remained the same as on date. Hence, I consider it fit to dispose of the instant transfer petition with the observation that in the event the petitioner faces any similar situation in future, shall be at liberty to approach the police or the court, concerned court. The matter shall be thereafter dealt with accordingly as per law and disposed of accordingly. Order did.
Same order will be. Yeah. Much of it.
Please, your lordship. Lordship, this is an appeal against conviction. There is also an IA for suspension, lordship.
I don't know.
How many years?
5 years, lordship, under 354 and section 10 of POCSO. I have served around 1 year, lordship.
All right, we suspend the sentence for now because we'll not have time for hearing. Third learned counsel. We'll pass the order.
Please.
Sorry to make a mention, lordship, item number 38. The date has been fixed as 6th of May. I'm just praying for this some early date, lordship, immediately after vacation, lordship. The petitioner is not keeping well. And what has happened, the co-accused has already been granted bail by the trial court, lordship. It's a POCSO matter. Notice has been issued, probably the service is not complete. Can it be taken after vacation, lordship, immediately after? And is also not keeping well, lordship. The charge sheet has been filed in this case, lordship. 38, 27. Obliged, lordship.
In the earlier matter, hearing bail, objection from both the